Party of Democratic Alliance against Cyril Ramaphosa and others, case number 0027 EC.
May it please you, my lords and lady, I appear for the applicant, the Democratic Alliance, Mr. Steyn SC. As I mentioned, my junior couldn't make it due to the rescheduling of the matter. Thank you.
S-T-E-Y-N.
It's EIN, my lady.
E-I-N.
Yes, yes.
May it please the court, it's Kesem, together with Steliano, Magudwa, and Mashlangu for the first and third respondents.
May it please the court, my lords and my lady, I appear together with Mr. Nongo and Ms. Raja. The surname is my nature. I'm appearing for the second respondent, the president, in his official capacity.
Right. Thank you.
Mr. President,
I'll give each of you just 5 minutes of uninterrupted presentation, just to outline your case. And thereafter, after you have the 5 minutes, you might start expecting questions from the members of the panel. But
yes.
I'll give you each of you 5 minutes of uninterrupted presentation. Unless, of course, if you want to waive immunity, that you can do.
Mr. President, Mr. Chairperson, I think it is correctly in this court. I waive immunity always, so I'm happy to address questions out of the block, but I will proceed. You have the benefit of our heads of argument. My prepared notes allow me to address you on 4 topics, and that is the jurisdiction of the court up front. I'm not sure how strongly it will be argued on the other side and what will be said, but I will address it and respond to it. The second is the relevant law applicable, the relevant electoral law. The third is the President's speech itself, which, as you know, is at the heart of this application before the court, and whether it transgressed the Electoral Code in particular respects. The fourth is the remedy. And finally, costs.
Okay.
So with your leave, Mr. Chairperson, the first topic is that of jurisdiction, and my client says that the court obviously does have jurisdiction. This matter raises squarely the question of whether there has been a violation of the Electoral Code. This question arises, and most notably, in the course of an electoral cycle, in the course of an electoral period. And that period, as we know, is designated in the regulations and in the legislation as commencing when the election is first declared, and culminating when the result is announced and declared. And so critically, this court has jurisdiction to hear the matter. The court, most notably in a recent case of Electoral Commission versus Remedies, which your Lordship and Ladyship may be aware of, found in very similar circumstances where a question of Section 87 of the Act and violation of the Electoral Code was concerned, that it did have jurisdiction and did allow direct access. The point that may be made...
Before you go much further, Mr. Steyn,
yes, my lord.
let's deal with the provision of the Act that confers jurisdiction.
That is 96.1. Yes. And my lord, that provision says the Electoral Court has final jurisdiction in respect of all electoral disputes and complaints about infringement of the Code, and no decision or order of the Electoral Court is subject to appeal or review. And My Lord, then is set out the jurisdiction, the remedial jurisdiction of the court, and there are a range of possible remedies. And of course, we fall squarely within that. Those are remedies which we ask of the court. My Lord, we are aware, of course, of the rules of the court, and in particular Rule 2 of the court, which provides and I take your Lordship and Ladyship. Excuse me? Yes, my Lord, indeed. And I'm happy to be referred to that, to take, which provides that in relevant part, and I think it's in particular, as Mr. Chairperson, you've referred to sub 3, a party may approach the court directly in respect of any electoral dispute or complaint about infringement of the code, and where sanction, and that is in particular subs H and I, and those, if I recollect correctly, but we can refer to it, is where there's a sanction of disqualification or cancellation of registration is concerned. And then, notwithstanding the provisions, any matter where special circumstances are present, with prior leave of the chairperson and at least 2 members of the court. So, my Lord, we say 2 things in respect of that. The first is that in the case of an electoral period, where there's an election underway, firstly, the court has jurisdiction. So there's no question of the jurisdiction. The only question can be whether or not the court has direct jurisdiction, or a litigant has direct access. And we say for 2 fundamental reasons it is. The first fundamental reason is that this is an electoral period, and in view of the circumstances in which the case is brought, it would not be possible to have a question like this adjudicated first by the High Court and then on appeal before this court. Because of the timing. What's wrong with the timing? The events that are the subject of this occurred on the eve of the election. To first go to the High Court, one would have to argue urgency, one would need to have a result, one would then have to apply for leave from this court to appeal. The second thing is that the court has readily, and the case of Reddy is the case I would refer you to, has accepted direct jurisdiction without a insistence on prior authorization or prior request or prior leave from the chairperson in the past. And that...
Doesn't that depend on the nature of the remedy that we set?
It does, but in Reddy, interestingly, there was an H&I, I'm going to call it for shorthand, a sub H&I, that is a deregistration or a disqualification question, remedy that was sought in respect of one of the defendants, but there were 2 respondents in that case. And in respect of that second respondent, the court heard the matter, even though there had been no prior request for direct access. And there was no insistence on a prior request. And that was a case, I might add, where the circumstances were not as close to the election itself as in this case, and did not involve squarely a question of the breach of the code of conduct, most importantly by the president, by the first citizen. So we would say that this is a case where the court would exercise its jurisdiction and exercise it directly. The second point that I will make is, as was indicated in our replying affidavit, out of an abundance of caution, the DA did seek the leave of the chairperson, and it did so on the basis of what was set out in the founding affidavit, and that is the nature of the breach concerned, being the code close to the election period, and so on. So that was specifically foreshadowed. The rules don't indicate the form in which a request for leave must be brought under the sub-rule of Rule 2. So we would submit that that's eminently a basis upon which leave was sought by our client. And I can give you the reference to that in our papers. That is in the replying affidavit at 544. para 23, where the jurisdiction point was taken by one of the respondents. So we would say we alleged sufficient facts in the founding affidavit. The jurisdiction point was taken, and my client then said, well, in that case, now, out of abundance of caution, we request, on the basis of what is set out in the founding affidavit, that leave be given in the event that leave for direct access is required. So we say it would really be in the manner of a dilatory defense, an attempt to burden another court with what is already before this court, if the respondents were to rely and be allowed to rely on that sub-rule 2 of the rules of this court. Ultimately, this court has the jurisdiction. It has the power to regulate its own process. The matter is before this court, and in the event that leave was required, that leave was requested of the court. And I emphasize in that regard, just to summarize, that the rules don't provide the form and manner in which that leave is to be requested. So we would say that that satisfies any requirement for request for leave for direct access in the event that it was necessary. So, my Lord, those are our submissions on jurisdiction, and just to draw a line under it, we would say, and of course you will hear from the respondent in that regard, but it would be an impractical and unfortunate situation if where a breach by the President of the Code of Conduct was in issue and the matter was before this court and all the papers were before the court and the hearing had been conducted, that another court should be saddled with the same question where the matter was already here, as the court already found, in respect of a breach of the code. So those are our submissions in jurisdiction.
Well, I only tend to hear this matter on a personal basis. I will do everything once I've concluded, once I've had you on the
Indeed, my Lord. So then we proceed. Indeed, my Lord. So we proceed to deal with the merits of the case in that case. I begin, and this is the second topic on which I address your Lordship, on the relevant electoral law. And we say in this regard, in common with all democracies, our electoral law prohibits, firstly, the use of public funds for the purposes of political campaigning, and secondly, the use of a position of power to influence an election, to influence the outside. Those are fundamental principles that one will find common to all democratic systems, and ours is no exception. And there are fundamental reasons for this that go to the heart of a constitutional democracy. It would be untenable if a person in a position of public office could use that position of public office to promote a political campaign. And that applies, and this is notable for this case, particularly with greater force where one is in an electoral period, as has been acknowledged by all of the respondents, and is the case here. The second is that it would be untenable if a person in a public office could use public funds for a political objective, because that is not a benefit that accords to others who are contesting those public offices. So those are fundamental principles that underlie the particular electoral laws that we have, and that the purpose of the electoral laws will be interpreted in the light of. It's clear what the purpose is intended to achieve.
Okay, before you go any further, we are bringing this case on the basis of Section 87(1)(g), Section 194, read with Item 9(2)(e) of the Electoral Code. And then we also rely on Section 19(2) and 3 of the Constitution.
Yes, so I'm sorry, ma'am.
These are the statutory provisions which we contend the President violated in his presidential address.
Indeed, my lord. I'm not sure that I heard your lordship's itemization precisely, but it is
Section
87, which is undue influence, and the code provision, which is 9.2, exactly read with the relevant provision of the Act, which is 94, I think.
Yes.
Yes. Yes, my lord.
Where is the use of privilege? Well, let's go to 90 of the thing. I think that's where it's dealing for you. Conduct.
Yes, item 9, 2E. Yes.
No person may abuse a position of power. Your contention is that the president has used his power, he used his office to advance the position of the ruling party ANC, the president. Then you say abuse privilege or influence. Then the right, well, to influence the conduct or outcome of the election. That's what.
Yes, they're disjunctive. They're power, privilege, or influence. And we would say, at the very least, the president meets that first criteria, position of power. If the president doesn't occupy a position of power, then nobody does. So that would be the first criteria. And we would say the president has a position of influence as well. Privilege, I'm not sure about, but certainly power and influence.
Then we need to go to what he said and what did he say.
Correct. So we will say in a nutshell, and I haven't got there in my argument yet because I'm still dealing with the law, but I'm guided.
Sure. I don't want to deal with the matter in the manner need to prepare.
But my lord, I'm also.
Deal with them, we can address us on the larger stage, but I think it's very much important at some stage to deal with the facts because the facts are started.
Most certainly, my lord. That was my topic too. But your lordship and lordships and ladyship have read the heads, and if you'd like to short circuit it, then I'm happy for that to I'm in your hands.
But are you done with the law now?
I wasn't entirely done, but my lord, your lordship captured it. The provisions that give effect to those principles are section 87(1)(g) of the Electoral Act. That is, firstly, that no person may use public funds other than those provided to the parties, because there's a provision that certain amounts of funds are provided for that purpose directly to parties. But that doesn't apply in this case. No person may use public funds for the purpose of a political campaign. That's the 87 injunction. And then the Electoral Code provides that no person may abuse a position of power, privilege, or influence, and then it gives certain examples, including parental, patriarchal, traditional, or employment authority to influence the conduct or outcome of an election. And that's the Code 92E, but you must read it, of course, with Section 94, which says that a person must not breach the provisions of the Code. So the items of the Code must be read with Section 94 of the Act. And I would make certain other points about these provisions. Firstly, the Code is binding from the date on which the election is called to the date on which the result is declared. And that is Section 99(1)(a), capital A of the Act. And that's important because it signifies, in accordance with the underlying purpose, the preserving of the even playing field, and that our law applies special considerations during that election period. That is to ensure an equality of arms amongst those that are campaigning during that contentious and excited period. And the respondents rightly proceed that that is because of the heightened, vigorous political activity during this period. And I take you to where the President concedes that. And that, we say, is vital for a free election. And that is expressly provided for in the Code and in the Act. The purpose of the Code is to promote conditions that are conducive to free and fair elections, free campaigning and open, fearless public debate with an equality of arms on an even playing field. And that is the Code item 1. So it's expressly provided for, that is expressly provided for as a purpose in the Code. And this, we say, could not be achieved if those in a public position could use those positions and the funding of those positions to promote their political cause. Because if that were the case, there clearly would not be an even playing field. The parties and individuals contesting the elections are contesting to be elected to those positions of office. It would not be an even playing field if those in the positions of office could use the resources and positions of office to campaign and to influence the outcome of the election. That is a bright line in our democracy and in common with all democracies. It's notable further in this regard that every party and every candidate must comply with the Code and must instruct their candidates and representatives to comply. And that is found in the Code in item 3. The Code goes further. The Act goes further. Every candidate is required to sign an undertaking to be bound by the Code. So every candidate, every party must actually sign a written undertaking that they'll be bound by the Code. And the failure to do so is a basis for objection and disqualification. And your Lordship and Ladyship and Lordships will find this in section 27, 2A and D of the Act. So we say in respect of the law, against this background, the argument advanced by the respondents, particularly on the interpretation of item 9, that it does not apply to the President for some reason, is untenable. The President is the best, the apex example of a person in a position of power. If anything, item 9 applies with greater force to the President. The President is the number one citizen. Our learned colleagues for the President in his official capacity have cited lengthy authority in their heads of argument, none of which we take issue with, regarding the presidential powers and obligations and his status to respect and protect and foster the Constitution. Those are well known to this Court. So it's in our submission a simply untenable, we might go further and say an irresponsible argument, to say that for some reason the President is not in a position of power and therefore isn't struck by the provisions of item 9, as has been argued by some of the respondents. That interpretation simply does not conform with those clear purposes of these provisions and with the objects of the Electoral Act and the Code. The converse would be unthinkable, that the President is permitted to use his position somehow to influence the outcome of the election. Just couldn't possibly be consistent with the very reason why we have these provisions. Finally, and the final submission I make to your Lordships and Ladyship on this, is what is the test for a transgression? And the parties, in fact, are ad idem on this. The test is an objective test. It's a question of what the reasonable observer would interpret the words to mean. What a member of the public, an ordinary member of the electorate, might think, reasonably may think. The test is not what the President subjectively intended. It's not our case, and I'll get to this later, it's not our case, given the President's statements on oath. We don't seek to go behind that, to say that he intended to strike the ball offside, that he intended to run offside. But objectively speaking, he was offside when he kicked for goal. And it's in that spirit that we approach the court as a referee in a dispute can I say, as family members, in the words of the President, and particularly now as family members, you are the referees. We were playing a game, and we say the President was offside when he kicked the ball. He may not have intended to be offside, our footballers seldom are, but he was offside on a proper interpretation of the rules.
Well, if the test is objective, what a reasonable bystander would interpret the President's speech.
Indeed. So it's not a question of did he intend. We don't seek to go behind the President's say-so that he did not intend. But his words were received, and this court will decide whether a reasonable observer may have interpreted it in the way that we say it is, and that is to transgress the provisions of the code. And I think the parties are at idem on this. And if the court needs authority for that, the authority we cite is LaRue versus Day. You'll find that in our heads of argument at paragraph 10, at page 10, paragraph 20.3. But it's conceded by the respondents. And it's conceded by them in the answering affidavit at page 114, paragraph 47.5, where they rely on other authority, which is the DA versus the ANC, 2015, bracket 2SA 532, at paragraph 96. So we understand that the parties are at idem that the test is an objective test. And we would say that that is in accordance with the objectives again, because even if you didn't mean your conduct or your words in this case, your act to breach the electoral code, even if you didn't set out to do it, if the way that they were received was to influence, reasonably cause influence, or to have used public funds, then that is sufficient to meet the purpose of the act. So it should be an objective test, not a. So not only do we say that the authority is that it is an objective test, but that it is properly an objective test, because.
I see my colleague on my left has got a question for you.
Yes, indeed.
Just two things. I mean, one doesn't unintentionally use public funds. So I don't think that you can
Yes, as I was making the submission, it occurred to me that well, having said that, and I don't mean to get into an obtuse argument, but you could perhaps do so. You could give an address which is funded, to use this example, funded as president. You didn't mean to use them for campaigning, but because you campaigned in effect, you didn't intend to use the funds for that purpose. You intended to give an address.
So you're saying essentially that if in the course of doing my ordinary job as president, it has the effect of campaigning, then I must be held liable.
Yes, if the reasonable.
And I can't do my ordinary job as president if it's going to have that effect of campaigning. I must double think every step if it's within an electoral period before I can do my ordinary job as president, to make sure it can't be seen by anybody as campaigning.
I would stop short of putting it as strongly as your ladyship has put it to me now. You must take every effort to abide by the code, and that includes this provision of the code. If you are in breach of the code, then even if it was not deliberate, then so be it. Then you were in breach of the code.
But that's why we have to interrogate how far the reasonableness goes, and how far the unintended action, the intention is necessary. Because if the president was literally doing what he would ordinarily have done as part of his job as president, and it also fitted in with what someone who was the head of another party, if they had done it, it was campaigning. Does that mean the president must not do it now because it is election season?
In his guise as the president. In his guise as the president. He
Yeah.
may do it in his guise as president of his party. Some parties have only leaders, not presidents. He may do it in another guise, but in his guise as president, he may not do it.
So if for the last 4-5 years he's been doing in a thing, he's been doing a thing, he's entitled to do it as president until the election was proclaimed on the something for February. So he's entitled to do it until the day before that as president, and the moment the election is proclaimed, he must stop doing it as president.
That may be so, milady, because that is why the code applies to an electoral period. There are special considerations.
It seems problematic.
Well, milady, that applies to all candidates and participants. It's not just to the president. Things that they could do on the day before.
That's why I'm saying when it's part of what you ordinarily do.
Well, things that you may ordinarily do at one time,
As your job.
once the code kicks in, because it's a time-sensitive code. It, by its nature, it's a time-sensitive code. So one can't, that is what the legislature has seen fit to provide us with, a time-sensitive code. Any time-sensitive code will have that result. It will have the. It will have the.
Proclaimed the election.
He's proclaimed the election, and everybody knows we're in the force of a fantastic festival of engagement that is our democracy. But if the oddity that your ladyship points to is the oddity of a date, well, that is by virtue of the fact the provision in that case, in the case of that provision of the code, and there's also the Act, is a time-sensitive provision. That is what it is.
Well, yes, but that's obvious. All the reasons that we know.
So by its nature, some things that people could do beforehand, they cannot
Like
do.
register to vote.
Well, to put it, yes, exactly. But conduct as well, there is, yes, indeed.
There's something that I just want to deal with, Mr. Steele, and that relates to the intention. Isn't the intention a necessary requirement? The intention. We have to establish the intention, the intent.
We say not.
Why? Let's go to section 94. I'll tell you why the intention is a necessary requirement. It says that no person registered party in the pages by bound by the code may intervene. And there's a penalty to failure to observe the code. And the penalty is the remedy that you are seeking here. You are seeking an order directing the person to pay the sum of 200,000, to be fined 200,000 rand, and to deduct 1% of the vote cast in favor of the ANC. So there's a penalty here.
It's a.
Why then the intention is not a necessary requirement in view of the consequences that might flow from the violation of the code? Surely the intention should be a requirement.
The Act distinguishes between criminal consequences and civil consequences, and we say that's a critical distinction.
Where does it bother?
Well, it says in penalties under 98, a person convicted of any offence in terms of these provisions, and it says elsewhere that in addition to these, let us call them civil remedies that are available, because these are civil remedies provided for, there are also criminal penalties.
Is it not the penalty? Is it not an administrative penalty? The fine of 200,000 rand.
We would say.
200,000. Is it not? It's a penalty.
We would say in the wording of other provisions of our law, the court has it really echoes the same provisions of the court's just and equitable jurisdiction elsewhere. It says that the court may grant relief including. If a court having jurisdiction by virtue of 24 finds a person of a registered party has contravened this, it may impose any appropriate penalty. It may impose any appropriate penalty or sanction on that person, including, and then it lists those. And we would say that's in the form of a just and equitable remedy in the same way that elsewhere is the case. It doesn't necessarily require intention. A deeper question, a more fundamental one, is ought the President to have known this? That we would say is incorporated in the reasonableness test, the reasonable objective person test. But it doesn't mean that strict intention, as is known in criminal law, is required for this provision, because it's in contradistinction to what is provided for in the criminal sanction, which is separately provided for under the Act. And that's in Section 98. So I'm trying to find the provision, and I will find it, but it says in addition to those sanctions that the court may impose for a violation of the code, there is also the possibility of a criminal offence. There we would say there's a good argument, but that is not the case before the court, that intention should matter. But in the case of violations of the code, in particular in relation to the effect that words have, whether they violate these provisions of the code, it couldn't just be the intention, because then somebody's defense could be that they set out innocently to not to campaign. But in effect, the way that they conducted themselves was received as a campaign. It was received as political words, and on any other basis would have been received as it. And on that basis, they would escape violation of the code. That we would say is an untenable and too narrow interpretation of the provision.
So your submission is that insofar as the intention is concerned, intention is not very final.
We would say for the purposes of this, a strict dolus directus is not required. Whether, I don't think it's easy to apply the normal standards of intention to this kind of provision. It doesn't. Perhaps dolus eventualis. Perhaps one could ask, should he have foreseen the possibility? Those are questions that incorporate some reasonableness test. But we would say that isn't the framework to apply to this, because this is in the form of a just and equitable remedy available to the court. And this court is not unfamiliar with that in all public law spheres. In the case of the Constitution itself, where the court has constitutional jurisdiction to grant a just and equitable remedy, and under statutes such as the Administrative Justice Act, where the same is true. That is the kind of remedy that we're dealing with here. We are not dealing with a criminal sanction. And that is clear on the express wording of the Act.
So you draw a distinction in that regard, is to say specifically between a criminal offence, a contravention of the Electoral Act or the Code of Conduct, which is expressly provided for as being a criminal offence versus a contravention of the Code of Conduct, which is not necessarily a criminal offence. Is that what you're saying?
That is so. And that's...
In the case, we say that there's not a violation.
That is so. That is so. And that is because we say they are clearly separately provided for under Act. Otherwise, the same conduct would amount to a criminal offence, but that isn't the case. It would automatically amount to a criminal offence, but it isn't the case. So...
When we just go to section 96, because that's a section that deals with what the court needs to do. Now, the penalty that the court may refers to appropriate penalty or sanction. It's a formal warning or a fine, not exceeding 200,000. But the moment you talk of a fine, doesn't the after the fine, issued the penalty element.
We would say not.
It's a penalty.
Well,
It's not a penalty.
My Lord,
Surely.
let us escape the terminology because the criminal penalties, let's use the word penalty, but there's a difference, let's say, under the Act between what we can say is akin to an administrative penalty, a sanction that is imposed for a violation of the code,
The section uses the concept appropriate penalty.
or sanction. So,
Well, the sanction will be up.
also, and that's significant
Why is it significant?
because it indicates that it is not, in the way that your Lordship puts it to me, a criminal penalty. It's a sanction. I prefer that word. We can use the word penalty if we say it's a different type of penalty to a criminal penalty for the violation of the code. The code has to find some way to remedy a violation of it. And the legislature has made for your Lordships and Ladyship a number of suggestions, but it's also said these are not the only possibilities. You may grant any appropriate sanction. That also, by the way, is different to a criminal case where it's more precisely put. But also, the Act separately provides for it. Says in addition to that, this may constitute a criminal offence. And there,
Let's forget about the criminal offense.
Yes.
Because we are still in the realm of 96. The penalty or sanction which is what we formal warning, a fine. That's where we are. Let's forget about other consequences that may fall outside section 96. We are not talking about criminal sanctions or criminal offences. I understand that the DA in its own affidavit is it's saying that it's still going to lay a complaint to charge. And I look forward to that.
I think it says it may. Yes, that,
Well, whatever language that it doesn't have, but it's clear in its mind that there is a possibility of laying a criminal
yes,
charge against the
yes.
president. But at this moment we're dealing with section 96. What is what penalty is called. So I'm saying it provides for penalty or sanction, the fine. The fine here has got an element of the penalty, and because it has got an element of the penalty, an intention will be required.
Lord, with respect, my submission is I don't agree with that last part of what your Lordship has put to me. There are many instances where the law imposes a fine, even though it does not require strict intention in the criminal sense of the word. Numerous come to mind, including those in an administrative context, many that are provided for under statute, where it is not expressed that one must have strict intention in order to be liable for the fine. When one exceeds the speed limit is a good example. If one exceeds the speed limit, one is liable for the fine, whether or not one says, well, I was distracted, I didn't intend it, I thought I was doing something else, I could have been, you know.
I mean, you know that the speed limit is 60 at a given zone, at a given area. And you exceed that speed limit, you say that there was no intention. Is that what you're saying? I didn't have an intention to drive beyond 60.
I'm saying that would not be a defense. It would not be a defense.
Why?
Because the speed limit is that, and one is required to take reasonable caution to stick to the speed limit. And that, we would say, it's not the only example, I've given one, but we would say that is the same kind of example as this, where this is the speed limit for the president, if you like, in this case. Or for other, let's not confine it at all to the president, to all of those who participate in the election. That they must be presumed to have reasonable knowledge of the code and not to do things that may have an impact And in this case, where it's words that may reasonably be perceived to cross the line. And I only say that the respondents rely on similar authority for the test, that it's how the words are received, whether they a reasonable person, let's call it a reasonable member of the electorate or any such example, received the words. And the president's burden, and any campaigner's burden, is to take reasonable precautions not to exceed the terms of the code. That is the standard that's put on it. It can't be a strict test of pure intent, because then to escape it, one would only say, well, I campaigned out of office hours, or I stole electoral ballots, but I didn't intend to do so. I removed them from the thing, but I didn't intend it. I picked up my suitcase and walked out, and there happened to be a box of ballots there as well. That, we would say, other than for the criminal sanction, which we've put aside, is not the test for a breach of the code.
Well, I think let's move to my next question to you. Would you look at the context in which the president is addressed, the content of his address, and the purpose of his address? I think that's why we need to engage. We need to engage with the facts.
Yes, indeed. So I'd
say what the president will say, and for us, in order to determine whether or not what the president said amounted to a violation of the code of the act, we have to consider the context, the content, and the purpose of his address.
Yes, approach it as one would any other text or active communication for which our courts have now indicated in Natal Joint Municipal Pension Fund or Coral Lagoon how that is to be done. That would be the approach. But may I just take one step back before leaving the law? I don't want my submission to be understood as saying that it depends what the test of intention is. If one incorporates a test of reasonableness in that test of intention, that then we would say does apply, because the president must have a reasonable perception, like any other campaigner or any other member bound by the code, of what the code provides, must take reasonable cognizance of it, and must take reasonable steps to avoid it. So if one is applying some sort of criminal framework, it would be a type of dolus eventualis test, if you like. But I use that very loosely, but it would incorporate a reasonableness test in there. If the test is pure intention, did I wake up in the morning?
If the test is a pure intention.
Yes, strict intention, what we would call dolus directus in criminal law. If it's that, did I wake up in the morning and decide if that is the only criteria? Obviously, if you did do that, you would be in breach of the code.
Well, that would fall under dolus eventualis.
Well, I woke up in the morning and I decided I was going to go out and breach the electoral code. That would be dolus directus. We would say that, of course, would breach the code, but it's not the only thing that would breach the code. One would also breach the code if one ought to have had a reasonable apprehension that if one did X, Y, and Z, given the nature of the code, then one would breach it. That, we would say, would do it. And if we would say we would go further, we would say, even if you didn't intend it in that way, but your words would be received by the general public, by the election, because that is the harm that these provisions are intended to guard against, would be received in that way, then that also would be a breach of the code.
Just to clarify, when you say would be received in that way, do you mean would be received as you intending to campaign? Or
As campaigning words. If there's a reasonable possibility that it would be interpreted as campaigning words, then as
intentional campaigning words?
no, as what would be considered campaigning words by those who are receiving electoral campaigns. The electorate is constantly engaging with political campaigns, And if a reasonable member of the electorate would consider that to be campaigning, that we would say would meet the criteria. So it's
So it's similar to the objective test that's in the Equality Act.
objective test in the Equality Act, objective test applied in LaRue v. States. It's the test that the courts consistently apply to speaking words. How do we understand the meaning? And in that case that the respondent cite,
Reasonably understood that you meant that.
if it's reasonably understood, that is the beginning and end of our submission. That was one place where the test was applied. In DA, the case that I cited to you that the respondents themselves rely on, which is...
Because at one point it seemed like you were arguing for strict liability, which is a different...
No, in fact, I had it under the heading, we believe that the submission is an objective test applies. Definitely that is not... So it's important that I make that clarification, indeed. It's a test of what the reasonable observer how the reasonable observer would interpret those words. In this case, in the context that it's an electoral season, that parties are campaigning, and so on. So, as you indicate, it's important then to go to the speech, members of the court. And I suppose it's helpful if you have the speech before you, because I am going to take the court through it in some detail. Obviously, I'm not going to rehearse it. The court will read it in its own time. But and that was annexed as HZ1 to the founding affidavit at page 27. And as your Lordship has correctly said, you approach it as the court has directed in all cases, as in the well-known cases of now reconsidered in Joburg, Natal Joint Municipal Pension Fund and Coral Lagoon and many others now. A couple of preliminary remarks about this. The first is, as you will see on the first page, it is entitled The Presidency. It bears the presidential seal, and it was billed as an address by the President of South Africa. The second important preliminary observation, as the speech itself states, but as also set out and conceded in the answering affidavit, it was given in prime time on a Sunday evening of the 26th of May. That was literally the eve of the election. As the President himself says, special voting commenced at 9 a.m. on Monday the 27th and 28th. And then the general vote on Wednesday the 29th of May. So this was literally the very eve of the general election, when parties were campaigning vigorously, in the words of the President. And you'll find that in the speech itself, but also in the President's answering affidavit at page 117, paragraph 54. The third preliminary observation is that it was carried on the public broadcaster and on the Presidency's social media platforms. That is, for example, the Presidency's YouTube platform and the so-called X platform, formerly Twitter, as an address by the President. No other political party or leader was or would be afforded this kind of access on the eve of the election. In this regard, political broadcasts that carry a political message, are carefully circumscribed. Again, another example of where a provision is more restrictive during the election period than outside of the election period, in response to my lady's question early on. In the terms of the broadcasting regulations, party election broadcasts are very carefully regulated during the election period. Parties are allocated equal time, a similar time, by the Independent Broadcasting Authority. And these are free. The one is allowed in those slots to provide them free, and they're limited as to time. They have specific, relatively short time when it is compared with a speech of this nature. Also, these are clearly for...
Before you go further, there's something that works now. So far, we have highlighted about 3 things which you say we have to take into account here. Now, the points that we have highlighted, if the president was acting in terms of section 83 and 84 of the Constitution, do you have a problem with that?
In other words, if the president was acting in his presidential role, naturally not. No, and I'll get to that, of course.
So far so good. The points that
Indeed.
just tried to highlight, those are just neutral points. Those are points that will be covered by section 83 and 84 of the Constitution, because it does
They're not neutral when read against what I'm going to take. That's why I have to put them as preliminary points. If this was an uncontroversial presidential...
Okay, let's say the addresses that he gave during his office, the family meetings that he did. So, all that you have said so far, the characteristics of the family meetings,
Absolutely.
speeches that he gave to the public.
And that's part of the founding case.
Let it be covered by section 83 of the Constitution.
Insofar as it stays on the right side of the line, of course, that indeed. But I'm highlighting these because I'm going to, of course, show the court how the president crossed the line, went off sides. So while this...
But so far, he's within section 83.
These are provisions that would be covered by Section 84. As soon as it's a party election broadcast or it carries a political message, you're outside, you're off sides. If you're not, then you're on sides, and it's covered by those provisions.
So far, so good.
So a party election broadcast is a direct address, broadcast free and advanced to advance a political idea or principle. That's what a party political point is. So those are specifically provided for, but the president, as president, because this was billed as, this was characterized as a presidential speech, was granted a special opportunity to address the nation. It was granted a particular, that wouldn't have been allowed to, and wasn't allowed to any other political actor, any other leader of any other party, any other candidate. And the fourth preliminary point is that it is common cause that the address was indeed publicly funded as part of the president's duties. The president says that he consulted with his advisors and so on. So it's clear that this was not paid for as a party election broadcast. It wasn't. It was done in accordance with the duties of the president and funded as an incident of the duties of the president. And importantly, the president has given an account of the speech. He indicates that the primary purpose was to allay fears of the public regarding security threats and to give reassurance of free, fair and peaceful elections, as well as to thank the IEC for its preparations for the election. And it's important that we go to those accounts. And I foreshadow, because your Lordship will put it to me, those are on side. Those are clearly on side. Those are well within the presidential tasks of the president. So may I ask the court just to go to some of those examples, because it's important to see how the president explains the purpose of the president's address on this evening. The first of them is at answering affidavit, page 104. Paragraph 18. The president there says As I explained later in this affidavit, I delivered my presidential address to the nation on 26th of May in my capacity as head of state with the primary objective of assuring the public of peaceful elections. And then if you go to the answering affidavit at page 106, paragraph 27, the President says, a head of state in my capacity receives regular briefings on any security threats to an upcoming and highly contested election. I receive these briefings from the law enforcement agencies and security establishment. I'm also Commander-in-Chief. Against the backdrop of the security briefings and based on advice, I can assess in advance whether additional national security measures are required. Goes on to say all of this. I don't want to read in detail, the court will go through this, but the essence is that he explains in some detail how there was a perception. He obviously doesn't go into privileged, restricted information, but there was he had received information and there was a perception in the country as a whole that there may be security threats to the election. Those are eminently presidential concerns and eminently appropriate subject matter for a presidential speech, a presidential address to the nation. And so he says there that his objective was to allay fears in this regard, to explain to the country, which is firmly within his sphere of presidential duties, that these security threats were under control and that the election would be conducted in a free and fair manner. And then finally, if the court will go to page 117. And I must add that the court will go through this, read through this at its convenience, but the President goes through dedicates quite a large portion of his affidavit to explaining this security objective and the objective to address the nation in order to ensure that they were confident that there would be fair and peaceful elections on that day.
Is there anything controversial?
Nothing, and indeed that's it's on side.
Okay.
It's on side, and
I'm interested to hear about the portion of the speech which you say are violating
of course, my Lord. But in order to do that, I must show how clear the line is.
Sure.
It's vital that I show to the court that while there may be difficult cases in the twilight, there are clear instances that are within the presidential role and are presidential in nature, and then there are those that are clearly offside, we would submit to. So at the moment I'm showing how, on the President's own version, the speech diverted from this primary purpose. And at 117, you will see again, the President says, in the 10 days preceding the election, South Africa's National Joint Operation Intelligence Structures reported that measures had been put in place. The President goes on in 58, referring to this. He refers to the spreading of fake news, unverified information, rumors of threats with the intention of causing confusion and inciting possible violence were also identified. And then he goes on to say that this, again, and as I say, there is a considerable amount of time spent in the affidavit dedicated to this. This was the purpose. This was the primary purpose, as well as to thank the electoral authorities and so on. So against that background, we must address the speech to see whether the President remained on side or diverted from that fundamental purpose. And if one begins at what is 28 of the record, the President says, firstly, I wish to speak to you about the country's readiness for the forthcoming election, and then to speak about the path we've travelled over the last 5 years. And then you will see tomorrow morning at 9 a.m. in voting stations and homes we begin to vote. Seventh time on page 29, the President goes on. importantly, he asserts that we will again assert the fundamental principle articulated in the Freedom Charter that no government can justify claim to authority unless it is based on the will of the people. Continuing, he thanks the IEC. As a country, we once again have witnessed the capabilities of the IEC in the successful voter registration weekends and so on. We convey our thanks and best wishes to the IEC. This is all on page 29 of the text. He thanks all election agents. And then on page 30, he goes on, and these are the lines that are dedicated to security on page 30. As in previous elections, our law enforcement agencies and security services have made extensive preparations to ensure that these elections are peaceful and that all South Africans can freely exercise their right to vote. And he reassures the public, correctly so, this is highly presidential, that security forces have been deployed and that they can meet any appropriate threat. He also commends all the parties that have upheld the Electoral Code of Conduct and refers to that one incident and says that we should all be concerned about it, about unlawful entry into the IEC storage facilities. The President says we once again call upon all parties, candidates and supporters to refrain from any action that could interfere with the due election process. He reassures the country that it will be a fair, peaceful election and that the security forces have things in hand. That's in those few paragraphs there. This we submit, and it's part of the DA's case, that's what's in their founding affidavit, is, I reiterate, an eminently presidential task on the eve of an election. But here is where the President begins to diverge from that path. The President says, we've endured a decade of corruption and state capture, of weak economic growth. He then goes on to address what, in his view, are the achievements of his administration. And that is, as we know, the administration that has the majority, that is the ANC administration that is competing in an election on the eve of the election. The first of these is that he says, the President says, that the administration has brought state capture to an end. That is a highly contested political concept. There are those that would agree with the President, there are those that would disagree with the President, or say that he has been less successful than is being portrayed in this. That is an issue that is at stake in the election. Parties are actively campaigning around whether that has indeed been achieved. Suggests that he's introduced new legislation regarding the NPA. As I'll submit to the court later, the legislation is not passed by consensus. There is a division in Parliament about whether one agrees with that legislation and votes in favour of it or does not do so.
Well, but the fact of the matter is that at the end of the day, the legislation is passed by those who support it. And if the majority supports it, then that's it. It becomes, it binds everything. Whether or not you agree with it, is it not so?
That is so, but he suggests that we did it as a joint endeavour, that was a joint endeavour. You'll see that he goes on to say our country and people were not spared the devil. He says that we endeavoured to do it as a joint activity. But my Lord, I'll get to the legislation aspect in a moment. The first is that let us put it in blunt terms. The first is we've ended state capture and corruption, highly contested in the political environment. Not all parties say that has been achieved successfully or that has been done. That is part of what is being campaigned on for the election that is beginning the very next day. Secondly, he says that they dealt effectively with COVID. Again, there are many contrarian voices. Political parties disagree and are permitted to disagree in a democracy with that, and are campaigning about their disagreement about how effectively the administration dealt with COVID and whether the correct policies were put in place. it is not, and I emphasize it is not for me, it is not for my client to say whether the president is right or wrong in these things, only that these are highly contested political concepts. They are at the heart of the election that is about to start the very next day. And the president is using the opportunity to say, we did this successfully. Whereas other parties, if they were standing with the president at the time, would say, no, 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 you didn't do it successfully. We've been telling you for months. We've been campaigning and you've been campaigning. You say you did it successfully. We say you didn't do it successfully.
Another way of interpreting what you're saying here specifically, and this applies to most of the other criticism at the level that he was getting, it can also be interpreted as the president saying we, as a country, we as South Africans, have been able to deal with the COVID pandemic. He doesn't say anywhere expressly, and I know that you want us to interpret this as saying that we as the ANC has done this, but it may also, is it correct that it can also be interpreted as saying we as a country, we as the people of South Africa have effectively and successfully dealt with this COVID, as a president would do. You know, it's a pep talk for his family.
My Lord, with respect, we would say, if that is the argument advanced, that is a highly tenuous and naive approach in the face of an election, because where you have political parties, and I'm going to take you to more of these examples, that are contesting almost every one of these notions, to say we have all dealt with this. You may use the words we, but in the face of an election where parties are saying, you did not deal with this. You did not properly achieve these objectives.
But now, looking at it, Timothy's speech, is it not about this telling us, this is according to the country, of the challenges that the country faced, about the achievement which the country's made, the threats of violence. That's basically the theme of the speech.
The threats of violence we've set aside.
Yes.
We've said that's firmly on the...
Yes.
These are contested political ideas that he's now presenting.
But he's talking about the past. What have we done in the past?
Well,
That's what
well, let's...
speech is sort of past looking as opposed to forward looking. This is South Africans. This is what we've done. These are the challenges that we faced. And this is how we dealt with those challenges.
Well, Lord, we'll get to the forward-looking part, because the President does say we must stick on this road and we must stick to this. But can we look at a few further examples of this?
Sure.
He says, the President says, law enforcement, that there was catastrophic, there was insurrection, this was managed to be prevented by his administration. Parties vigorously campaigned. I'm going to take to you. When in our country would go up in flame, the people of South Africa stood firm against those who wanted to incite insurrection. We proved our democracy remains strong. He says, when in April catastrophic flooding took place. No, that is correct. That is not an instance where he does. When in April catastrophic flooding struck parts of KwaZulu-Natal, the Eastern Cape, Northwest, South Africans came together to provide material assistance to those affected and to rebuild. One of the points that you'll see it's analysed later on, is that parties are campaigning precisely on that there was an insufficient response to that government's response was lacking on that. Let's go on to further ones, if I may just be allowed to, and then we can interrogate them.
But isn't that the point, that he is saying that South Africans did it, not that government did it?
But in the face of a political campaign, where your party is saying, we achieved this and this and
but
that.
This is not him saying, my party did this.
But
And we all know they didn't.
Well, when the president is using
When
his...
we talk about July 2021.
Well, but that would be if that were the concession made by the respondents, that would be a fatal concession. If they're saying we all know he didn't do this, then it takes it over the line. But the point is that we didn't do it. We didn't do it. There are some that would align themselves with that and that it was successfully achieved, And there are others who would say we didn't do it. We failed in doing it. The next one is load shedding. Load shedding. He says we've successfully confronted the debilitating electricity crisis. We came together as social partners. That is a highly contested idea. Almost every other political party would say there's been an abject failure to deal with the electricity crisis in South Africa. And so when you present this as an accomplishment, you are in effect presenting this as a political speech. You're saying this was achieved. And if we were having a debate, if this was an open debate where all parties were given an equal airing at the same time on a Sunday night, they would all be saying, Mr. President...
If you are presenting it as an accomplishment.
That's...
You are saying he's presenting it as something that South Africans as a community have accomplished. If you're presenting it as me on my street saying on my WhatsApp group, my battery has run out, I've got caught in an hour, can someone help me charge my laptop? That is us confronting a debilitating electricity crisis and coming together as social partners.
My lady...
So that's what I'm saying. It's a question of interpretation, and you are saying we must interpret it a certain way because it's a political campaign speech, but it also can be interpreted a different way as not a political campaign speech.
Well, when you are relying on your record as in a force, as the President says, to use his words in these proceedings, in the face of vigorous political campaigning, and you say, we have combated load shedding, we confronted COVID correctly, let's allow for the use of the terminology we, saying we as the family have done that. When members of the family would stand up if the family were at a family gathering and say, Mr. President, that is utter nonsense. We're in an election campaign.
We did this because you caused us to do it. What about that also?
I'm sorry, my lady.
No, I'm saying as members of the family, Dad, we had to do this because you made us do it. Is also a valid response.
Well,
as if it was a political campaign speech, if it was a political debate, it would go. But that's the point, is it's all open to interpretation.
But it isn't, because he's saying we accomplished this. And what the election is about is whether it was accomplished. That's what the election is about.
But is it not saying that's the challenge we face? This is how we dealt with the challenge. As South Africa.
As you will see when you read it, it says we have successfully dealt with it. And it concludes by saying that is why we must stay the course. That is why, and that is a call really to, and the President, as President of the ANC and as a campaigner, is utterly entitled to that. And this is an important debate to have. I don't want to, it's crucial to the heart of this matter. But when you are standing up as the President and you are presenting as family accomplishments, accomplishments that are contested in an ongoing election, that members of your family, let's use that metaphor, are actively saying are not accomplishments. You failed us, Dad. You didn't deal with the electricity crisis. You didn't properly deal with COVID. Education is a disaster. All of these themes that are taken up, to put up to the country that we have achieved this, is a political statement in an election campaign. It is not simply a president objectively describing the way that accomplishments have been achieved. It cannot be interpreted reasonably in any other way, because each party, and I'm going to take the court to this shortly, has been addressing precisely these issues in their campaigning. Precisely, and they are fundamentally contested. So if a president, under the guise of his presidency, can simply address these highly controversial topics and say, well, I'm just addressing them as the president, and I'm telling you we've achieved these accomplishments, and that makes them not political statements, that would undermine the very purpose of the election, because then parties don't need to engage in robust political activity. We all know that they're accomplishments, and the president has...
Well, Mr. Stein, I had hoped that by now we would have finished submission for 12, because of the debate that we presented as companion to we went beyond whether we start.
Yes, and I will do...
I hope that we need to done by
Yes, my lord. And I will be brief, my lord.
So, but because I think that it's only fair that I should take a break, break.
I anticipate I will need 10 or 15 minutes.
I think that, let's take a break. I think it's 27 now. Let's come back. What I do? Let's take a 15 minutes break. While the court will adjourn until 22. right, thank you. May I proceed, Mr. Stein?
My Lord, I just want to wrap up my submissions on this
Yes,
issue
please.
by referring to a few things. My Lord, in summary, the President refers to a number of themes that are highly contested in the election. In each case, he says, for example, the President says, we have provided support for more than 1,000 black industrialists. That is not the family we, that is the we of the administration, because we as the family have not done that. We have worked across government and NGOs to implement the presidential employment schemes. Again, that can never be interpreted reasonably to be the we of the family. That is the we of my administration, of my political administration. We have increased the number of police on the streets. That can never be interpreted as the we of the family. We have worked to implement the national minimum wage. We have doubled the numbers of students receiving NASPAs. We have worked towards silencing the guns throughout our continent through the diplomacy and deployment of the SABC. It is the President that is that has decided on those things, not the we of the family. So we say in summary, and then, my Lord, the President ends by saying, at this moment in our path of renewal, we cannot afford to turn back. That is the small we. That is the we of the family. He's saying, my policies have been good, my achievements have been good, and you should continue on this path. That we would submit. I submit on behalf of my client. That we submit would be very well placed. It's highly acceptable in an election campaign in the course of a party election theatre. It is not. It crosses the line in the context of a speech to the nation by the President on the eve of an election. And there are three fundamental ways in which this is overlooked. The first is that this is done critically during the election period, which is declared by statute and defined. The second is that each of the accomplishments which the President claims is heavily contested by one or more of the political parties in the very election period that one is involved in. The President cannot contend that he is merely reasonably objectively stating these accomplishments. That is the very purpose of the election, to contest whether those accomplishments have been achieved. But even more profoundly, in a constitutional democracy, in the third place, in many instances, the policies themselves are politically contested. And we give one example, but there are many. The EFF, for example, contests that there should be private funding of electricity. The President lauds that as an achievement. So those are the very things that parties are campaigning about. And it's not just campaigning in general, because it is campaigning in the middle of an election. And in this case, it is the most sensitive time of that election. It is the very eve of that election. No other party, I reiterate, would be allowed to trumpet its accomplishments or its policies in this way. Rightly so. And the President certainly can't do it just because it is under the guise of a presidential address to the nation, however well-meaning. We've analyzed, my client has analyzed, the extent to which those very issues overlap, firstly, with a speech that the President gave the very day before as President of the ANC, when he was in his election regalia. It doesn't change the political nature of those statements. It doesn't change the political nature of those statements when the President is doing so from the platform of President of the country. They remain political statements, they remain contested political statements from a constitutional perspective. And for that reason, they are protected by the code. When the President does so while wearing his hat as President of the ANC at a political rally, they are invited by our democracy. When the President does so under the guise wearing the hat of his position as President with a capital P of the nation, that is offside. the president has strayed offside because he is abusing that position of presidency in order to trumpet his political achievements, and he's doing so in an electoral circumstance. The respondents have gone further. They've helpfully further tabulated the extent to which all of the political parties raise these very issues and contest these very issues on both levels, whether they have been achieved, as the president says we have achieved them, and secondly, whether they ought to be achieved, whether they are laudable political objectives. Both of those are profoundly important to a constitutional democracy. They are at the essence, they're at the heart of the election that is taking place at that time. And so to stand up and trumpet these as achievements and to purport to present them as accomplishments of we is a sleight of hand, a political sleight of hand. It uses the position of presidency of the country, presidency with a capital P, to promote political ideas. And it does so in the force of an election. That is where the president, in our submission, clearly steps off sides. And it's important that that issue be adjudicated upon by the court. That is why it is brought here. The charge on the part of the respondents, and I will deal with the extent to which they address these things in reply, but the charge on the respondents is, well, firstly, by tabulating the further instances where all of the political parties raise these exact issues, and that the court will find at that table is at the answering affidavit, page 128, paragraph 89. The tabulation of the fact that all of the political parties raise those precise issues in the course of their campaigning and contest whether they've been achieved or whether they are laudable political objectives effectively concedes the issues, because it says that I raised in my speech the very issues that parties are adamantly and vigorously campaigning about and contest on those grounds. And then secondly, the response of the respondents is that the DA is cherry picking from the speech. So a great deal, the charge is a great deal of the speech is onside, but the GA is cherry picking the points that are offside. That too is obviously a concession. The DA in its founding case says, we accept that a portion of this speech was presidential. It was in furtherance of the president's duties, and I took your lordship through those. All that is necessary for them to demonstrate a breach of a code is one instance of offside, and I have alluded to numerous instances of that, because the president delves into the very issues that are the subject of the election on the eve of the election. So we say that in our submission, the president used his position of power, which is the position of the presidency, to influence the election. He was welcome to have done it at a campaign rally for his political party. And secondly, because he's funded, he used his public funds, and it's admitted that he was public funded for the purpose of the political campaign, because these are campaign issues that his party and all other parties were actively campaigning against. In both of those instances, he transgresses the act and the code, although only one of them is necessary. So that then takes me to the fourth topic, and that is the question of remedy. And the first point to make is that the court, as we've already discussed to some extent, the court has a wide discretion to impose any appropriate remedy. The legislature has just given the court a series of recommendations, but those are by no means exhaustive. This includes a fine not exceeding 200,000 rand and an order reducing the number of votes in favor of a party. The key remedy, the first remedy and the crucial remedy that my client seeks is the declaratory relief, because it's more important than any of the other relief that if this court does see the president as having strayed offside, that the court declares it as such. And that is the first prayer that is requested. And I can't emphasize that enough. That is the critical relief that the DA seeks in these proceedings. That the court declares what the law is and whether the conduct in this conduct the president has strayed across the line. The second remedy sought is for the fine, which the DA persists in. But of course, the extent of a fine, we say it's appropriate in light of the fact that the president is the first citizen. He should know better. He shouldn't use that position to promote his political campaign, particularly in the case of an electoral cycle. And it's appropriate that a fine be levied. Of course, the court has a discretion as to where that fine would fall in the event that it was minded to grant it. The DA has asked for the maximum available fine in that regard. They would say that's warranted by virtue of the position of the president. The third relief that was initially sought, the DA no longer seeks. That is water under the bridge. The election has occurred, and the DA doesn't seek the reduction of the voting in the manner that was initially sought. So I emphasize that declaratory relief is crucial. The DA does persist in a fine, which it said would be a mark of the sanction that the court would apply for transgression of the code, as it does in other cases, but not the reduction of the vote. That is an extreme remedy, and it's not sought here. Finally, in respect of costs, the DA seeks costs on the ordinary High Court scale, according to Scale C, which is now as presented. Doesn't persist in a punitive cost order. As I say, we accept the good faith of the President on the version that has been put up in the answering affidavit. But of course, that does not change the results, meaning that if there's been a judged to be a violation of the code, then it is appropriate that costs should follow the result. We go one step further, we say if the court is against the DA, is against my client, then this is definitely a case for Biowatch. The DA is seeking to vindicate the Electoral Code and the Act. It does so not only in its own interest, although that would be sufficient for Biowatch, it does so in the public interest. It is right that parties that seek to test these principles should not be mulcted in costs and therefore chilled. That is the essential message of the Biowatch case. So we say even in the event that the court is against us, this is a case where no order as to cost will be made. And I know that the one set of respondents is not asking for costs. I'm not certain about the others. We'll hear from them in due course. Those are our submissions on costs, and our submission is in general, unless there is something more from the court.
Thank you, Mr. Stein.
As the court please.
Yes, Mr. President.
I'm not going to take much time on both points. The first point is that this court is not a court of first instance. We term it the jurisdiction point, but it's really a point of whether they should be entitled to come to this court as a court of first instance. Now, your lordship knows from the Ready judgment that the Ready relief that they sought fell squarely within 96, my lord. One, I'll give the lordship the exact reference. 96 2H. The remedy sought there was that Ready be disqualified in terms of 96 2H, and that, my lord, is an exception in the rule itself, which your lordship referred my learned friend to rule 2.3. A party may approach the court directly in respect of any electoral dispute or complaint about an infringement of the code where sanction referred to in section 96.2H, and that applied in the Ready case, or I of the act is sought. And then of course your lordship there said, because Kanyele is before us, it came as one application, and more fundamentally, there was a referral by the commission itself, there was a report, so we're exercising effectively appeal or review power. This is what it's all about. The court said we'll deal with it. And then our learned friend says, but look at 23B, notwithstanding the provisions of Sub-Rule 1, in any matter where special circumstances are present, with prior leave of the chairperson and at least 2 members of the court. And there he says, look, we dealt with it in the reply, and your lordship knows that a case is not made out in reply. But there's this element of opportunism here, my lord, because what they say is in paragraph 23, after not having a word about special circumstances in the founding papers, out of an abundance of caution, the DA submits that there are special circumstances warranting this court to hear this matter. These appear in the founding affidavit. Simply put, there are few electoral matters more important than those involving allegations that the president abused his powers to influence an election. What will the court consider as special circumstances? The court will consider the following. Make out your case in the founding affidavit or seek relief as part of the notice of motion why this court should sit as a court of first instance. There's nothing of that. Now my learned friend says, well, there isn't any elaboration on the rule itself as to how it should be done. And any practitioner knows, my lord, if you're looking for an indulgence from the court, then you make out the case in your notice of motion read together with your founding affidavit. So this, my lord, the point that they came to this court as a court of first instance, my lord, should not be accepted, my lord. More particularly because the court doesn't have the benefit of the very analysis which took up the bulk of the argument on the merits between the court and my learned friend when looking at the content of the speech itself. Never mind the test, I'll deal with that in a moment, my lord. But the context of that normally is done before the court of first instance. If a high court judge would be sitting, they say on the Plascons Evans case, you haven't made out a cause of action. That debate, my lord, now has to take place in this forum in the court of first instance, and that is the abuse. So we would submit, my lord, on whether the court has jurisdiction. Of course the court has jurisdiction. But whether the court should hear this matter as a court of first instance, we submit not. There is, my lord, an element of arrogance in the reply where they said, oh well, look at the founding affidavit, it's so important. That, my lord, is itself a presumption. You can't ask a court to say, we think it's an important matter, therefore allow us to come as first instance. You go to court and you ask for that indulgence. And you either make out a case or you don't. So we would submit, my lord, it's distinguishable from the Remedies judgment. That's the argument on whether the court should entertain this as a court of first instance or not.
But I hear you, Mr. Casimir. If we look at the notice of motion, there is a relief that is one of the remedies sought is declarator. Where would you put that kind of a relief? Is it a relief that falls within 96 section 196?
You ask in the
Section 96(2), because it's, as you are well aware, in way that there was no application for, well, the notice of motion didn't seek a declarator, was not a remedy, was not a prayer that was sought, was not one of the relief that was sought.
So ordinarily, my lord, it looks at the notice of motion where they say
because there's a in the notice of motion there is an order, there is a prayer seeking an order declaring that the first respondent to the president's address violated section 94, 87 and 192.
I see that, my lord.
Yes.
But I would submit to your lordship, that's where it finds itself, like any other matter. You say, condoning coming to this court as a court of first instance for the reasons more broadly or articulated in the founding papers, and then you make out your case in the founding papers. And then the court will say, well, either there are special circumstances or not, and your court will grant that relief, or your court will say that on the facts of this particular case, the presiding judge, together with two members, consider it in the public interest to hear this as a matter of first instance. But that, you can't jump that. Otherwise, my lord, you might as well do away with Rule 2.3 altogether. The effect of Rule 2.3, if my learned friend says is simply for the asking, then it has no impact. That's the end of it. Then don't have the rule. But once you got the rule, you must comply. And if you haven't complied, then the right thing to do is to say, I'm not pursuing this now. I'm bringing a separate application to see if I can persuade this court to hear it in the public interest or the interest of justice. And ordinarily the court will say, go to the High Court. Let's get the benefit of see how they deal with the factual dispute. There's a serious factual dispute here, my lord. And that debate must take place because this court ultimately sits as a court of appeal or review as a final court. Now, I understand, my lord, there are those cases that say if there's a constitutional issue, the jurisdiction is retained. But as the Act itself provides, you sit as a court of final relief. And it's an abuse to come to this court, my lord, on this particular application. And then to try to sneak in and make out your case, my lord, contrary to our law, my lord, where you make out your case in the founding papers. Opportunity says out of abundance. They don't even acknowledge, my lord, that they've bypassed the rule. They actually say, we are entitled to be here. They're not entitled to be here, my lord. That's the starting point. Those are our submissions, my lord, on that point. Then, my lord, and I know my learned friend for the president in his capacity as a president is going to deal with it more elaborately, my lord. But I have to make out the points on the test. My learned friend really says the test is Leroux versus Day, which was an action based on the Lex Equalia. And in dealing with wrongfulness, the court says, well, that's really how the conduct is perceived in the broader public interest. It is really an objective test. Here, my lord, there's no issue, my lord. If your lordship looks, and your lordship took my learned friend to the section itself, when your lordship looks at, and this has been dealt with, my lord, in the DA case, under 94, no person, registered party, or independent candidate bound by the court may contravene or fail to comply with the provision of that code. In any other law, the Chief Electoral Officer may institute civil proceedings before a court, including the Electoral Court, to enforce the provisions of this Act. Then, my lord, we have the code set out, but then, my lord, it says under 98, the heading is penalties. Any person convicted of any offense in terms of, including 94, is liable to a fine or to imprisonment for a period not exceeding 10 years. Now, my learned friend tried to argue, my lord, there might be a difference between sanction and penalty. Either it has penal consequences or not. Now, the best, perhaps, factual analysis, my lord, is what your lordship will find in the founding papers, and that's at paragraph 55, where the deponent says, finally, I note that Mr. Ramaphosa's conduct also constituted a criminal offense in terms of section 98A. So my learned friend's argument where he says, whatever, rendering him liable to a fine or imprisonment of up to 10 years, the DA intends to lay a criminal complaint against Mr. Ramaphosa. And your lordship knows that this is dealt with in terms of what approach the court will take. It's dealt with in the DA judgment, my lord, in the Constitutional Court, in paragraph 154 of the judgment of Mr. Justice Cameron, where he says, presumption against strict liability, a further issue.
Sorry, just give us a citation.
Yes, my lord. This is DA versus ANC, 2015, volume 2, SA 232, and I'm going to read at paragraph 154 and 281. And I think your learned sister, Judge Yakub, raised this with my learned friend. A further issue needs to be addressed. This also follows from the ground rule of our law that penal provisions must be strictly construed. There is no suggestion, and the ANC did not claim that the DA sent out the SMSs knowing that what is termed constitutional false information. I don't think it's necessary to read further. The principle is that once you are looking at penal provisions, you apply a restrictive approach. And my learned friends distinguish between dolus directus and dolus indirectus. Well, my lord, that really comes down to mens rea. The test hasn't changed since Rex versus Jolly, my lord, when we were in law school and studied criminal law. You either know what your consequences are, or you can, by reckless conduct, foresee the consequences. Once you do that, then the court will say, it's intention. There's no degrees of intention, my lord. Either you intended a certain act or you did not intend it. So that entire debate of trying to mix up, getting confused with civil law concepts of subjective intention and objective evidence need not bother this court. Your lordships will say, was there an intention to breach these provisions, bearing in mind your lordship repeatedly referred my learned friends to the relevant provisions of our Constitution, Section 83 and 84, that this is the head of the nation, allaying the fears of the nation before the election, that security measures has been put into place, and then elaborating upon the virtues of the right to vote in a democratic state, what democracy can achieve. And over again, the President says, we as a nation have come together, and this is what we have achieved. Now, whether you think it's sufficient or not, my lord, he's speaking, my lord, as the head of a state, saying to the people of South Africa that if you conduct yourself in a democratic fashion, in other words, you abstain from intimidation, from violence and all wrongful conduct, and you take the right to vote seriously, then this is what democracy can offer you. That's the context of what Mr. Justice Adams says. That's the context of what Lord Scruton, if he was awakened in his sleep today, and as the reasonable observer will say, well, he'll say, that's what I think the President is saying as head of the state. Well, then that's the end of the argument, my lord. So I don't want to take up unnecessary time, my lord. Yeah.
Let's accept that for the sake of argument, 90% of the speech is that. If 10% of the speech is, to use Mr. Stain's terminology, offside, does that then get us into trouble?
Well, if the court finds intention, then yes, quite clearly. I mean, that would be, if it, and I'm just using this without demeaning the president, but say you get a clever president, a shrewd president, and we've seen them now in world politics in America. We've seen that now. Now, he uses this opportunity to promote the party, but in such a way that this court comes, and there my learned friend is right, ultimately you the judge, you the judges. You say, but look, if I look at this carefully, this is such a connived, elaborate scheme to actually promote the ANC under the guise of what the sixth administration has achieved. Some will argue not enough, others will argue very limited, others will argue far better than one would expect in trying times. But that's a judgment of the individual. But if the court comes and says, look, this was really a scheme to achieve that, I don't know how you do it on paper to start off with, because that's a really, it's a drastic finding. But
no, but that wasn't my question.
The question is, you're right. I mean, if there was intention, there's intention.
No, my question is, 90% of the speech is what it says it is.
Yeah.
We've done this, let's be proper South Africans and do a free and fair and safe and peaceful election, and let's not intimidate anyone, and let's go do this properly. Let's say 90% of the speech is that, but then we find that 10% of the speech is vote for the ANC because the reason we're here is because the ANC did this, and this. Then that's my question. If most of the speech is exactly what a president should be doing,
and there's one or two things which step over the line, then it's a breach of the code of conduct.
It's a breach, but a magistrate sitting in the magistrate's court hearing a criminal trial will look at it holistically, will look at it in context, and it is, I would submit, very unlikely, unless there's a clear, well thought out scheme to achieve that, very unlikely to say, on the facts of this case, there was intention to breach the code. But that's a finding that the
Yeah.
trier of fact will have to make.
Yeah.
Difficult to make in the context of 90% being good, 10%. It's not a clear-cut case like the flow of funds, for example.
And there would be a difference between finding that the president specifically decided to hold this family meeting in order to slip in that 10% or 5% or 1% or 30%, or that he held the family meeting for the 60% or 90% to say let's have a proper election, and then slipped in something else. There's a difference.
Absolutely. On the civil test, highly improbable. On the criminal test, difficult to prove beyond reasonable doubt. But that's what you got to find. You got to fight. As I read the authorities, you got to find intention. You can find dolus eventualis. That's part of intention. But to get to that finding, certainly not on the founding papers presented to this court. I would submit.
There's something that bothers me, Mr. Hassan. I just need your clarity on it. And that's the following. Now, the penalty that is imposed under Section 96, is it the same as the penalties that are imposed under Section 98? Because it would seem to me that the penalties that are imposed under Section 98 are the penalties that follow upon a conviction of a person for an offense. Whereas in this case, it's a sort of a civil remedy. I want you to understand what I'm trying to explain. They are pursuing the civil remedy, and the fine that is going to be imposed is the fine that follows upon the finding that a person, the president's speech, constituted a violation of Section 94. Now, if they've built their case on Section 96 true, what kind of an intention is required to be established? Is it the intention, would fault suffice if a reasonable man in the position of the president wouldn't have made that speech? What kind of an intention would suffice for the purposes of establishing a violation of Section 94? If you bring your case under, if the remedy that you are seeking is a remedy under Section 96(2).
So this is my submission, my lord. In cases of contempt of court, we have a distinction where the High Court judge can say, I'm not finding you for criminal contempt, but I'm finding you for civil contempt.
Yes.
And there the test would be balance of probabilities. But that's an inherent jurisdiction that the High Court exercises. And I think the Brown versus the Brown case, sorry, not education, the Brown versus EFF, and the acting judge, Judge Helens's analysis in the court Arco, concludes that when the High Court is an electoral court, it has the powers of the Electoral Court, not its inherent jurisdiction. Because this is important, my lord. Because when you come under 96, you are now confined to the remedy 96. And therefore, the test has to be pure intention. Because this court can't say, and my learned friend, with great respect, started talk of just and equity relief and looked at the Constitution. Usually you do that when you now finding where else can I find relief here. You're dealing here with a statute, and I don't mean this is any respect as a discourteous, but ultimately you're sitting in terms of an act of parliament, you've got to find your powers in that particular legislation. And here it seems to me, contrary to where the High Court is sitting and makes a distinction between contempt of court, civilly and criminally, here it seems to me that once you choose 96, you look at the remedies, then you have to prove pure intention. I don't think this court can say, look, we're satisfied on the balance of probabilities, we want to give the declaratory relief. I don't think that would assist, my lord.
Mr. Casson, surely the question whether you have breached the code can't have a different answer depending on what penalty you're seeking. The penalty you're seeking will affect the onus of proof. But that's the only thing it will affect. It can't affect what the elements are that have to be proven.
I agree with that. In other words, you've still got to prove
It's
that
still
you
the same thing.
deliberately
It's
did
either
so.
a breach or it's not a breach.
Yes.
In the civil context, it's a breach on the balance of probabilities. In the criminal context, it's a breach on beyond a reasonable doubt.
Agree with that, my lady. I can't really add more meaningful to the debate, other to say that if the court is mindful to giving cost, then we do appear pro bono, but there's authorities that your court can give cost, and we will ask the court to give cost in favor of the juniors only, not my learned friend Mr. Stiliano and not myself, my lady. We come from the old school. If you're doing something pro bono, that's the end of the matter. Thanks. Thank you.
Sorry, I just want to get your take here. As far as the merits of the dispute is concerned, is it your argument that the President address did not constitute a violation of Section 94?
Correct. Thank you.
Thank you, Mr. Manager. At a debate that the court has been having with Mr. Stein and Mr. Kassim, what is your contribution to the debate?
I have quite a bit to say, my lords and my lady,
Yes.
because it is my client's speech that is at issue, and it is the misconstruction of that speech and the provisions of the relevant statute which has brought the DA to court. We will be submitting that they misconstrued the speech and have interpreted certain sections of that speech out of context. And most importantly, that they haven't applied the discipline of first understanding what the meaning of those provisions that they rely on is in order to found their case. And so what I propose to deal with are 4 issues. The first issue is the proper interpretation of Section 87(1)(g) and 94 of the Electoral Act and Item 9(2)(e) of the Electoral Code. That's the interpretation issue. That's quite important because one doesn't jump into the speech to determine whether it breaches the provisions of the section without first understanding the meaning of those sections. That's the first. The second is the President's address must be interpreted applying the same principles of interpretation that one applies in respect of statutory interpretation. Because the courts have said the rules of interpretation apply to all written documents, whether it's a contract, it's legislation, it's a court order, you apply the same rules of interpretation. Then thirdly, I'll deal with the question of penalty, and I shall then conclude. But before I do that, I just need to give a short backdrop that provides a scheme of where we premise our argument. Firstly, let me say we associate with the submissions made on jurisdiction. We didn't take the issue of jurisdiction in our affidavit, but jurisdiction is a question for the court. The court could raise it mero motu. So we associate with those. The second point by way of backdrop is...
With Mr. Kassim's submission.
Mr. Kassim's submissions, yes. By way of backdrop, my learned friend Mr. Stein on a number of occasions said the President concedes that and references the answering affidavit. Most of those are explanations that the President gives in the answering affidavit by way of answer. It is incorrect to characterize them as concessions. and I shall place them in proper context. The second point about the, just by way of backdrop, is the way in which the founding affidavit selectively reads or quotes from the speech. And I will, when I deal with the concluding remarks of the President, demonstrate to you the stark way in which they characterize the conclusion, and my learned friend persisted with that sort of characterization. The second is in understanding the purpose of the speech. That too, the DA emphasizes one part of the explanation and not the other part of the explanation. And I'll take you to the paragraphs in the answering affidavit. What my learned friend did was to read you paragraphs of the founding affidavit where the President is setting out for the court the security concerns that, with the advice of his advisors, led to the holding of the giving of the address. But he never takes you to the culmination of that discussion, where the President says, ultimately, this was the purpose. Now that's important because my learned friend says we accept the bona fides of the President in his answering affidavit. But in any way, on Plascon Evans, that is the affidavit you look to understand the context in which the speech was made, what the purpose of that speech was, to the extent that it is not self-explanatory from the speech itself. Now, let me take you to the issue of purpose, because that's quite important. And here is the point. They say the President started on the right path and then slipped. We want to show you that the President started on the same path and ended on the same path. And you were referred to pages 117 of the answering affidavit. I want to take you further to page 119, which builds up to what he describes to be the purpose of the speech. At page 119, you'll see paragraph 61 tells you about the IEC's own noting of the concerns, about security concerns, and that it dismissed some of those concerns for its purposes. And earlier than that, he also referred to the nut joints and the report they produced about all of these shenanigans that were taking place that could potentially threaten the elections. And then at 62, he tells you what his advisors advised him to do, which was to follow the format of what has generally now been called the family meeting, which he has used to respond to questions around COVID-19, to load shedding, the July uprisings, and so on. Having discussed all of those factual matters, he then says at 63, ultimately, it was the security concerns and the need to assure the nation that adequate measures were in place to address them, and that the nation should not be derailed in going to the polls to vote. Voting is critical to the future of our country, especially in the light of our history. This necessitated my urgent address to the nation ahead of the elections. I sought to also remind all of us of the challenges we faced collectively in the past and overcame as a collective. I emphasize that this is what characterizes us as South Africans. We must, again, go out as a diverse but united and vote for the future of our country. Not doing so could lead to our country to regress. Now, just bear that in mind, and I'll take you to his concluding remarks in the speech, that it sticks consistently to this. And then he explains, to avoid causing panic, my speech addressed the readiness of the country for the forthcoming elections. I emphasized the integrity and preparedness of the IEC and other institutions responsible for conducting the elections. This is a responsible way of assuring the public that the elections would be secure, free, and fair. Highlighting the threats could have played into the hands of those making threats for selfish and nefarious reasons. It could also result in substantial numbers of people staying home and not coming and not voting. My address was also aimed at promoting national unity and instilling confidence in the democratic process, thereby mitigating tensions and reinforcing the importance of peaceful, fair, and transparent elections. This is consistent with my past addresses to the nation as head of state, i.e. calling for unity and strength in our diversity. In the process, my speech also closed off the work of an administration whose term was ending. It merely reflected a status report on our collective achievements. A new administration would emerge post the elections. The nature and constitution of that administration would depend on all South Africans going out to vote and knowing that voting would be free and fair. So what's the president doing? He's reminding us, he's assuring us that the elections will be free and fair. Measures have been put in place. Don't stay back. But that's not enough. He reminds us that we face challenges. We have overcome them as a collective. We don't want the country to regress. How do you ensure that the country does not regress? How do you ensure a better future for the country? You go out and vote. And so he's assuring and encouraging South Africans to go out and vote. That is the duty of a president. And I shall refer you to the EFF judgment of the Constitutional Court, where they properly characterize the functions of the president under Section 83 and 84. What he did here is consistent with that. Now, to his speech. They suggest, my lords and my lady, that he started well, but he slipped. Either because they are dancing around on fault, they suggest maybe he slipped unintentionally, but the effect is that he's in breach. Or maybe he slipped intentionally. I think the deponent, Ms. Zille, doesn't say he slipped unintentionally. She kind of says she uses the word shield. I had to look it up. That's almost like stealing. So he stole the occasion for the benefit of the ANC. So that's not slipping up unintentionally. That's directly by design. But is that borne out by the speech? The president starts off, my lords and my lady, and you referred to this at page 28. He says, fellow South Africans, we're used to this. You will see that every moment he moves to a new topic, he says fellow South Africans, and that's the mode of most leaders do that, just to remind you, so you're paying attention. Fellow South Africans, I wish to address you on two matters this evening. He doesn't hide it. Firstly, I wish to speak to you about the country's readiness for the forthcoming elections. Secondly, as this sixth administration draws to a close, status report, I wish to speak to you about the path we have traveled together over the last 5 years. Together. And that's why you get numerous occasions in the speech, references to we, South Africans, the country, the collective, institutions of state in the country, social partners, private sector, all working together to overcome challenges. And he says, in conclusion,
the problem seems to emanate from the fact that there is a reference, there is a constant reference to administration being a administration under his political party. I wonder if it was possible for him to have used a different concept
we can wonder,
to describe whatever body that has been in charge for the past 5 years, rather than using the word administration, because obviously that's, or the government.
Yes. It's probably correct that he could have used all manner of descriptions.
Yes.
Ultimately, my lords and my lady, the question for the court is not what he could have done, is whether what he has done breaches the Act. And I'm going to start off that debate by looking at the provisions of the Act, looking at his speech, and saying, what conclusion can you reach? And our submissions is that the conclusion you'll reach is that he hasn't breached the Act. So the reason, I'm not being flippant in my answer, the reason is, as the court repeatedly pointed out to my learned friend, the powers of the president are in Section 83 and 84. They're general powers. They're stated in the most general terms, other than Section 84(2), which says you exercise them by doing X, Y, and Z. Otherwise, the power of uniting the nation and moving us forward is a general power given to him. He's left a wide discretion by the Constitution on how he achieves that. Another president doesn't, other presidents have not given us family meetings, have done things differently. That is not to say that any one form is ipso facto in breach of the Act. One must look at the Act, one must look at the conduct to determine whether there's a breach. Just to go back to the point I was making, is he starts off clearly saying, this is the path I'm going to follow in my speech. There's no slipping. He tells you where he's going. And then he talks about all of that, which we'll come back to. I'm not arguing the content yet. I'm just giving the outline. And then in conclusion, he says at page 35, fellow South Africans, towards the foot of the page, fellow South Africans, moving to a new topic, he's concluding. The last 5 years have been a time of rebuilding and recovery. He doesn't say by my administration, by all of the people he's mentioned, collectively. He says it has been about working together, not only to meet the challenges of the moment, but to put in place firm foundations for a better future. As this 6th administration draws to a close, and as we prepare for the 7th administration, let us build on the progress that we have made. He doesn't say the progress that my administration has made or the ANC has made, us as a country have made. At this moment in our path to renewal, we cannot afford to turn back. Now, they say renewal is ANC rhetoric. Therefore, he's talking about ANC rhetoric. That's again, he's taking a word, putting it on a white chalkboard and saying, what does it mean? Who does it relate to? And the courts have said to us, that's not a proper way to interpret. You interpret everything in context. You read the statement as a whole. He says, at this moment in our path to renewal, we cannot afford to turn back. There is more work to be done. Let us draw strength and encouragement from the difficulties we have overcome together. I call upon all South Africans to go cast their votes. We are a diverse people, but a united nation. It rarely borders on the ridiculous to suggest that when he says we are a diverse people, he means these diverse people are going to vote for the ANC. It's an acknowledgement that there are plurality of views and political persuasions. He said, let's go vote, bearing in mind that we are diverse, but we are a united nation. What are we united about? Let us be united in our commitment to our democracy. It's a multi-party democracy that our founding mothers and founding fathers have given to us. Let us work together to build a better country. May God bless South Africa and protect its people. They want you to read, my lords and my lady, that this conclusion says, let's go out and vote for the ANC. That's just a wrong reading of this, of what the president says. And I'll come back when I deal with the content, just to highlight how this is taken out of context and given a cynical interpretation, and we say that with respect, by the deponent to the DA application. I turn, my lords and my lady, to the proper interpretation of the provisions that the DA relies upon. My lords and my lady, I do this painstakingly because the DA doesn't attempt to do so. It assumes that it's obvious what political campaigns are. When you talk about political campaigning, you're making a political speech that conveys a contested political idea. That's what they say. Well, politicians, by virtue of their office, that's what they do every day. They don't give sermons. But that's not what the prohibition is about, and one must look at what it says. And there are various guidelines to this interpretation. The first is the guideline one gets from the Democratic Alliance versus the African National Congress. This is the SMS case, and we have copies of the judgment for the court. And I might at the same time give the court the judgment in Brown, which my learned friend Mr. Kasim referred to, which is relevant to the question of fault, either intention or negligence. The first critical guideline is what the court will find in paragraphs 122 to 135 of the ANC DA versus ANC. I'm not going to take the court to all of those, the discussion in that judgment. I'll just paraphrase what the judgment concludes when it says the provisions prohibiting.
Just give us
the moment the limits appear.
There's a thick one, which is the DA versus the ANC, and then the thinner one is the Brown judgment.
The thinner one. Yeah, they're all okay now. Okay, thank you.
I'm not. We've referred extensively to the DA versus ANC in our heads, and the principles that it distills at paragraphs 122 to 135. The majority judgment of 5 judges. I think Justice Cameron and Froneman, I can't recall the third judge, Judge Kampepe, which is then concurred in by 2 other judges, becomes the majority judgment. At 122 to 135, they deal with the approach to interpreting these provisions which prescribe certain conduct during elections and imposes significant penalties. What they say first is this, that the provisions must be restrictively interpreted. And they say what that means, my lords and my ladies, that if there is any doubt as to the meaning of a provision that prohibits conduct during elections, the sections they rely on, the court must interpret the provision against the risk of being penalized. So if there's any ambivalence in the provision or uncertainty as to what it means, you interpret it restrictively to limit the risk of being penalized. There are a number of reasons which are identified in those paragraphs that I referred the court to. The first is that the provisions limit freedom of expression. Because during elections, as Justice Cameron says and the 2 judges, freedom of expression is the lifeblood of a proper democratic election. But what the provisions do is to limit it. So that's the first reason why you restrictively interpret the provision. The second is that they impose severe penalties for breach, ranging from the fine of 200,000 to losing a percentage of your votes. The significance of that is far-reaching because it means you're disenfranchising voters who voted for the ANC. Their votes will be lost because they won't count. The third is that the breach of the provisions also constitutes criminal offenses under Section 98. And may I say here that Section 98 contains its own penalties in a criminal setting compared to the administrative penalties that one finds under 96 and Lordship presiding, Justice Zondi, you're quite correct in drawing that distinction. So they ultimately say that these provisions, and these are the words they use, and you'll find in the judgment in those paragraphs, these provisions are, they say they are tough provisions. As if that's not enough, they say very tough. That's what the Constitutional Court says. And that is the reason why when you interpret them, you prefer a restrictive interpretation to avoid penalizing. So the reasons are, it limits freedom of expression, imposes severe penalties. The breach also constitutes a criminal offense. These are very tough provisions, very tough indeed, as the court says. That's the first guideline for the court. The second guideline, my lords and my ladies, is what the court knows and does every day. That is, when it interprets the President's address as a written document, it will read it as a whole and give it meaning. It will read it in proper context with regard to its purpose. It will not depart from the words used, the point of departure in interpretation will be the words used by the President. And the DA glosses over those words in order to drive a meaning. Even where the President says, we have achieved X, they would like us to believe he's talking about his administration and indirectly the ANC. That's very important. That words, context, and purpose. And you must give the address a sensible meaning. And that's what Ndumeni says. A sensible meaning, not an insensible one. And they Democratic Alliance versus the ANC, that judgment, helps us also in describing the context. Recall that context is both the legal context and the factual context. The legal context here is would be how the courts have characterized the purpose of these provisions. What do they do in an election? What do they achieve? That's an important legal context, because you must bear that in mind when you read the provisions. And so you will find at pages 137 to 138 of the DA versus ANC judgment, where they deal with part 1 of the Electoral Act, and part 1 starts with section 87, prohibited conduct. That's chapter 7, part 1. So they deal with that, and if the court turns to paragraph 137 of that judgment, and recall they were dealing with intentional false speech, and they were trying to give meaning to what that section means. What does intentional false speech mean in that context of that section? So you must identify what type of speech is it talking about. And in paragraph 137, the court says, part 1 groups the statute's prohibitions together. It creates several criminal offenses. These are also, as explained, subject to the Electoral Court's additional sanction and penalty powers. In summary, these are prohibitions on undue influence, particularized as prohibiting any person from compelling or persuading voters to register or to vote, or interfering with the independence or impartiality of the Electoral Commission, impersonating a voter or candidate, intentional false statements, the provision at issue here, infringing a voter's right to secrecy in casting a ballot, unauthorized use of voting to election materials or the voter's roll, defacing or unlawfully removing billboards, placards, or posters, obstructing the Electoral Commission, the Chief Electoral Officer, and other officers, and contravening the code. In 138, it is evident from the setting in which section 89 appears, it's the same setting as section 87 and 94, that its prohibition on false information is designed, as are most of the other prohibitions grouped with it, all that you find, primarily to protect the mechanics of the conduct of an election, voting, billboards, election stations, observers, vote counts. It is directed to protecting the rights enshrined in section 19 of the Bill of Rights, namely the rights to make political choices, to free, fair, and regular elections, and to vote and stand for public office. Here, that the prohibition relates specifically to false information is an indication, bolstered by the context, that it is election-related information that must not be falsely disseminated. And seen in this context, the false information prohibited by 892 would thus, for the most part, relate to the kind of statements that could produce the effects set out in the provision itself. These are disrupting or preventing an election, creating hostility in order to influence the conduct or outcome of an election, or influencing the conduct or outcome of an election. In other words, a contextual reading of the provision suggests that the kind of false statements prohibited are those that could intrude directly against the practical arrangements and successful operation of an election. In our context, 9(2)(e) tells you is to avoid an influence on the conduct or outcome of an election. So you must read what is that abuse that is aimed at, is an abuse that will have the effect in the section. The 87 doesn't tell you the effect, but we will show you that there's an internal textual indication of what it means by political campaigning, and it's not what our learned friends contend for. So we submit that what context comes out of Democratic Alliance with the ANC is that these provisions that we are dealing with here are designed primarily to protect the mechanics of the conduct of an election. So they're concerned with the mechanics of the election. 2, they are directed to protect the rights enshrined in section 19 of the Constitution. And 3, the provisions are aimed at conduct that could produce the effects that are set out in the provisions, like in the 9(2)(e). Read contextually, the provisions are aimed at conduct that could intrude directly against the practical arrangements and successful operation of an election. So that asks you to really apply yourselves on what those provisions mean, and not simply to equate political campaign to propagation of political ideas that are contested. It means it has a particular meaning. So we start first with the question of meaning, and the second point I'll deal with is the question of fault, intention or negligence, or whether fault at all or whether this is strict liability. I turn to the question of meaning first, and after that I'll come to the issue of fault. I turn to section 87(1)(g), and that, yes.
I just want to, if you are going to get to it, that's fine, but if you were not going to get to it, then please do get to it at some point.
Yes.
When you're dealing with context, Mr. Steyn made a great deal of fact that what we're dealing with here is notionally the most powerful person in the country with the greatest deal of access to a number of ways of reaching the public. And I'm interested in how that fits into what you would regard as the legal and factual context in which we deal with this. Firstly, in terms of how the notional breach is interpreted, and secondly, whether it is relevant to the breach or whether it is relevant to the remedy.
Yes. So perhaps I could, I'll come to it, but as the court remarked, the provisions of the Act mean the same thing at all times and for everyone. The sweeper who wants to contest elections and a president who is a candidate. So the provisions are not lax when you're applying them against the president than when you're applying them against the sweeper, because the Constitution sees them all as right holders. But it is a relevant contextual matter, but it doesn't answer the question whether there was a breach, because the breach must arise from what is the conduct that is prohibited. Does his conduct cross that line? That he could easily cross the line because he's got access doesn't mean he has crossed the line. Otherwise, the law would apply unequally between presidents and some of us. So section 87(1)(g) is headed undue influence. And you recall from the description of the context in DA versus ANC that they pointed to the fact that some of the grouped provisions deal with prohibition against undue influence. And it says, no person may, G, use public funds except for the funds allocated to a party in terms of Section 5 of the Public Funding of Represented Political Parties Act 1997 for the purpose of a political campaign. So we understand public funds, but what is a political campaign? There is no definition of what a political campaign is in the legislation. So it doesn't define that. So the court must give it meaning. Given the contextual matters that I referred to, restrictive interpretation, the purpose of these provisions, and the proper interpretation to statutes. But we submit that there is a textual assistance in the provision which sheds light on what a political campaign is. And it is the reference to the Political Party Funding Act, the Funding Act. Because what it says is, political parties are allowed to use public funds, but only those funds that are allocated to them under the Funding Act for purposes of their political campaigns. Otherwise, they cannot use public funds sourced in any other way. So the president, in this case, we accept. In the address, he used public funds. It was, he uses resources that are provided by the state to plan the speech, to present it. All of that are public funds. But what did he use them in a political campaign? And the political campaign, the meaning of that, we suggest, must be arrived at by understanding the activities that the legislature allows political parties to fund using public funds allocated under the Public Funding Act. And that Section 5 of that legislation is helpful. We haven't provided a copy, and it's a bit difficult to find it on LexisNexis. I had to just print it off the internet, but we can provide a copy of that. So the
What section did you say?
Section 5 of the Public Funding of Represented Political Parties Act 103 of 1997. And you'll recall it starts off by establishing a represented political parties fund under Section 2, and then it deals with deposit and investment of monies of the fund, and in Section 3, and Section 4 deals with the management and control of fund. Then Section 5 deals with the allocation from fund. That's the one that's referenced in Section 87 1G. It says 5.1a, subject to this Act, every political party is entitled to be allocated monies from the fund for any financial year that it is represented, one in the National Assembly or in any provincial legislature, or both in the National Assembly and any provincial legislature. And then it says, subject to subsection 3, the money so allocated to a political party may be used for any purposes compatible with its functioning as a political party in a modern democracy. These purposes include, amongst others, Roman 1, the development of the political will of people; 2, the bringing the political party's influence to bear on the shaping of public opinion; 3, inspiring and furthering political education; 4, promoting active participation by individual citizens in political life, could be elections and voting; 5, exercising an influence on political trends; and 6, ensuring continuous, vital links between the people and organs of state. And then the qualifying section, subsection 3, was said subject to, and we know it means subsection 3 is the more dominant provision. 3 says, monies allocated to a political party from the fund may not be used for the purpose of remuneration, and so on, it lists. So what it tells you, what this legislation tells you, is that public funds can be used by political parties for these political activities, including campaigning to influence public opinion, or voting, and the like. And that's allocated to you. But you can't use otherwise other public funds not allocated to you for these activities. Now, when you look at these activities, they're very clear. These are organized political party activities. So the Siyanqoba rally falls squarely within Section 5. It is a political party organized activity, a rally for elections. But the speech is not. The president's speech is not, because the DA accepts that the ANC was not involved at all in conceptualizing the idea of a speech, planning the speech, writing the speech, organizing its presentation, nothing, nada. They accept that. So it is not a political party activity. That is why the DA is driven to interpret political campaign to mean, they say political campaign means basically propagating a political idea that is contested. But if the idea behind the prohibition in Section 87 was to prohibit the propagation of a political idea, period, all political speech is prohibited, there would not have been the use of the words political campaign, it would have been political speech. Because we know in the Bill of Rights there is under freedom of expression the concept of political speech. So the legislature is not unaware that it could choose a clear political speech. Any political speech you can't make during elections. That's the first. But it would also have not contrasted it with Section 5 of the political party funding, because all it would be aiming at is we are prohibiting all political speech. It doesn't matter whether it's organized by a political party or is by the president giving a political speech, because the president gives political speeches probably in his office, exercising his office more than 99% of the time. He talks about power, he talks about what the government is doing for all of us, which is contested, all of that. This is all political stuff. That's what politicians do. So they want to, unlike what the Constitutional Court says, you must interpret this restrictively, they're giving political campaign a benevolent meaning to catch every form of speech that propagates a political idea that is contested.
But now, these things that are listed in Section 5, which is mirroring Section 7 of the new Political Funding Act, which replaced the old one, those are all things which also fall within what Mr. Spain considers to be onside, like encouraging people to go and vote.
Well, but you see, the difference is that he says you're encouraging people to go and vote for the ANC. He's got to make that leap, because to encourage people to go and vote doesn't breach 87(1)(g. It's not a political party campaign.
Yeah.
They're not campaigning for people to vote for a party. And that's the case they make, is that you must infer that every time he talks about we or administration, he's talking about the ANC. And so when he says, let's go out and vote, he says, let's go out and vote for the ANC because we want to continue the renewal, we don't want the country to regress. But when you look at his concluding remarks, he's not saying any of that. He's not saying any of that. So I had an interview this morning about what a founding father of the U.S. Constitution was asked whether the founding fathers gave American people a monarchy or a republic. And he said the founding fathers gave America a republic if you, the American people, can keep it. If you think about that in this context, the president says, if you think about our context, our founding fathers and mothers gave us a multi-party democracy. If we can keep it, but to keep it, we must vote in our diversity and our unity. To maintain the diversity, plurality, not to discourage that, and to do so as a United Nations, to keep that democracy. That's precisely what the president says in those paragraphs at the end. He is assuring and encouraging. He is not saying, unlike political campaigns, we will do this and that for you in future to meet the challenges that we may not have met. And here, my lady and my lords, the DA says that the president scored an own goal by including the manifestos of the political parties and highlighting that the issues they raise are similar. Some of the issues they raise are similar to what he raised in the speech. He says that to make 2 points. That what he was saying were challenges are everyday experiences of every South African. And if you look at all the political parties, they're talking about the same things. He's not shying away from that. But he's saying, I'm just talking about up to this point. I'm not canvassing forward. Now look at what the DA manifesto.
don't agree about how those things should be dealt with. So on those parts of his speech where he deals with how those things would be dealt with, rather than just generally we have dealt with these things.
Yeah.
Is that not, if not over the line, very close to the line?
That's not the test, with respect, that the statement he makes is not political campaigning if it receives universal acclaim. Because...
No, that's not my question.
Yes.
I'm talking now about the on-side, off-side thing.
Yes.
Right. So let's say we all agree that unemployment is an issue.
Yes.
we don't all agree on how we deal with unemployment.
Yes.
And if he says in his speech, reading from page 32, more than 5.7 million workers received wage support through the special UIS scheme.
Yes.
Now, that's something that the ANC government is taking credit for, which one assumes the DA government, if and when there is one, would not want to pursue. So
Yes,
that's not saying we as South Africans have done this.
Yes. Well, he's making a statement of fact. He's not saying how we dealt with this is the right way. So the DA can't fault the fact that that happened.
That it happened.
They can say, if we come in, we're going to create more jobs. You won't need UIF. They can do that. They do that in the manifesto. But that's forward-looking. That's campaigning. And that's what I was going to refer the court to, page 179 of the manifesto, of the DA manifesto. You just have to look at the content, the table of contents, to see what a manifesto does. Because that is an organized political party campaigning message. It says, the DA will rescue South Africans from unemployment. The DA will rescue South Africa from the energy and water crisis. The DA will rescue South Africans from crime, corruption, and lawlessness. The DA will rescue South Africa from cadre deployment and failing service delivery. The DA will enable people to rescue themselves from poverty and inequality. The DA will rescue learners from a failing education system. The DA will rescue South Africans from a failing public health system. It's their plans. They're selling their plans. I've not had a party that campaigns in an election says, I've governed the Western Cape for the past 5 years. As to what I'm going to do in the future, I'm silent. Vote for me. No ways. That's what campaigning is about. And that's how one must understand the provision. Because what the provision is really saying is, don't use political party funding, other than that allocated to you, don't use public funds, other than political party funding, to promote your party in order to get votes. How do political parties promote themselves to get votes? They say the current government is failing, or there are other issues that they haven't addressed. We will address them like this. The ANC in Siyanqoba and their manifesto say, we've achieved some, there are challenges. Here are 10 plans we're going to put in place to resolve all of that. That's political party campaigning. That is what you cannot use public funds for. But to suggest, with respect, that a president of a country on the eve of an election cannot appeal to South Africans to vote because as a collective we have made certain achievements, and if we don't vote we run the risk of losing all of that, and assuring them that that vote will be free and fair and peaceful because measures have been put in place to regulate the election. With respect, is a far cry from what is prohibited under the Act. That is not what the Act says. But anyway, remember, I'm merely submitting that on the issue of interpretation, they just fall right there before you even get into the content of the speech. So on 87.1G, with respect, we submit that they have failed to try to understand what a political party campaign is. It's not sufficient to say that it is a speech that conveys a political idea. That's not what the legislature has prescribed. And the clearest indication is the cross-reference to Section 5 of the Funding Act. So that's on the interpretation question, and we say that's completely consistent with the what is required in reading those provisions, that one must read them restrictively. So that's the point I think Justice Yakub was making, was that the old Act is now replaced with the new Act. That's why we can't find it.
Yeah.
But it retains the same. It retains the same thing. So the legislature is always aware of what it's doing. It knows what it's writing in the Electoral Act, and it knows what it's writing in Section 5. It can't speak with They can't be double speak.
It is presumed not to.
Exactly. And we accept that presumption until it's shown otherwise. It hasn't been shown, not even an attempt.
I see.
Then-
Sorry to interrupt you. I see now it's 1:10. The lunch adjournment. I don't want to unfairly detain people.
Yes, I won't finish quickly.
Yes.
Because I'm
You still have a lot of ground to cover, as we
Yes.
indicated.
And understandably,
So-
so I was going to move to section 94 and item 92E, but I'm happy to do that after the lunch break.
We can't forget to 2 o'clock. All right, the court will adjourn until 2 o'clock. Thank you, the court adjourns.
you.
All right, you may proceed, Mr. Manager.
As the court pleases, so I'll move to section 94 and item 92E. Section 94, as the court knows, gives the code a force of law. It says no person, registered party, or independent candidate bound by the code may contravene or fail to comply with the provision of that code. And then item 9 itself is headed prohibited conduct. And under the item that the DA relies on says no registered party or candidate may abuse a position of power, privilege, or influence, including parental, patriarchal, traditional, or employment authority to influence the conduct or outcome of an election. My learned friend submitted that some of the respondents argue that the president's position, official position, is not a position of power. That is not a point we make. We accept that is a position of power. But the question for the court really is whether the president abused his official position in rendering the address to influence the conduct or outcome of an election, because that's the harm that is prohibited by that provision. And the court will have to give some meaning to the concept of abuse, and we submit that abuse in that context would mean that he used his office and the address for an improper or ulterior or unauthorized purpose. So he used it for a purpose that the Constitution doesn't allow him to use the power for. And the purpose was to influence the conduct or outcome of the elections. And it's important because the DA identifies what that outcome is that he wished to influence is an outcome of the election in favor of the ANC. In other words, to win votes for the ANC. It's not merely that the elections would have had a different outcome, but it is that the ANC would win votes in consequence of that purpose. So we would submit that if the president used the occasion for a proper or authorized purpose, but it could incidentally also benefit the ANC, one can't say there is a prohibition. So he uses it. Let's take an example. He says, the examples that have been given. We provided support during COVID to small businesses through an UIF provision, and that's correct. He also says, in the context of COVID, as social partners, we assisted other businesses. As the country, we overcame COVID. So he makes a number of statements around COVID. But I accept that if one isolates one statement, it's possible that that statement could be seen as one that might incidentally benefit the ANC or benefit his government. If one says, well, a person watching would associate the administration with the ANC, that's not what he's saying, but assuming that it's possible that somebody might see it that way and contend that, well, that might not be what he set out to do. That may not what he set out to use his office for. But incidentally, in one sentence, there might be a benefit for the ANC. That's not the prohibition. The prohibition is an abuse. So you set out to do exactly with your office that which the Act prohibits. It's not, you did the right thing, but incidentally there might be a benefit.
Sorry, while on the point, item 9E
Yes.
has got two components. It's to influence the conduct or outcome of an election. Now, does the first part there apply to a situation? Influence the conduct of an election?
It doesn't apply because...
It doesn't apply.
It doesn't apply.
How do you influence the conduct of an
Precisely.
election?
So if you recall the DA versus the ANC, the court said when you influence the conduct, you're influencing the mechanics, the arrangements of the election. But that's, and that is not the same as encouraging people to vote. You are interfering with how the election must independently be organized by the IEC and run by the IEC, the mechanics of it, the arrangements of it.
Surely it must mean to unduly influence the conduct.
Yes.
Because if you influence the conduct by encouraging people to behave in a tolerant manner, and that has that effect, then that's not undue and it's not prohibited.
It's not an abuse, yes. It's not undue, therefore it's not an abuse. So, and that is something, and we will say, when you to give content to his functions and to determine whether he abused his office, you go back to look at what his functions are under 83 and 84. But I'll get to that in a minute. The point we're making simply is the legislation is not aimed at prohibiting incidental consequences. That's why it uses the words abuse. In the case of political campaigning, you're using the funds for a political campaign. You're not using the funds to encourage the nation, but incidentally, the public, members of the public might say, but this is a good president. We're going to vote him into office again. That is not prohibited by the Act. He's performing his function. Incidentally, it might portray him in a good light because he's acting properly presidentially. That is not what the Act is prohibiting. It's prohibiting that interference with the mechanics, the arrangements, and protecting the right under Section 19. So if the conduct is not out to interfere with all of that, it's not conduct that these sections are aimed to prohibit. And that is the context that the DA versus the ANC gives properly in those paragraphs that I refer the court to from paragraph 135. And so I suggested that in order to understand whether he is abusing his office, one must understand what the duties of that office are, and whether what he's doing is staying true to those duties, or as my learned friend would say, he's crossing the line, he's offside. Unfortunately, we don't have we don't have the video to check whether he's accurate. Well, in a particular instance, one can check scientifically the offside metaphor. But the point is simply, so the court goes back to what are his functions, and we say they are in 83 and 84. And 83, Section 83 of the Constitution says the President, A, is the head of state and head of the national executive, and B, must uphold, defend, and respect the Constitution as the supreme law of the Republic, and C, promotes the unity of the nation and that which will advance the Republic. So when he says, go out and vote to secure a better future for South Africa, and we are going to secure these elections for you to vote, he is advancing that which will benefit the Republic and the multi-party democracy that we all want. And what happened? You have a multi-party democracy through this election, which the DA is now part of sitting on the table. And he promoted the unity. He emphasized we are diverse, but united in advancing our democracy. And then Section 84(1) specifically says, the President has the powers entrusted by the Constitution and legislation, including those necessary to perform the functions of head of state and head of the national executive. So you can see, he doesn't only have powers that are expressly listed, he also has powers that, including those that are necessary for him to perform those functions of the state. So a different president might have stood up and said, there's this party and that party who tried to break into voting stations or interfere with storage or voting booths. We've got our boots on the ground. We're going to make sure that that doesn't happen. But there's still a lingering concern, but I encourage you to go and vote. Now, some people, extra cautious, might have decided we're not going to vote. Or they may all go and vote. That's one president. Another president uses his power of persuasion. He says, I'm going to assure and I'm going to encourage. And people turn out. Both of those are legitimate exercises of the power that is given to the president under the Constitution. And Justice Mogoeng, Chief Justice then, Mogoeng, in the EFF case, captured this very well about what the president's duties are. Both the parties, by the way, quote from that paragraph 20 of that judgment. We've quoted from it in our heads at page 15, paragraph 40, page 15, paragraph 41. We've quoted from that judgment the description of the president's, and it's very enlightening in the language that the Chief Justice only could use. It almost gives you a dramatic sense of what the president is there to. It almost gives you a dramatic sense of what the president is there to do. You get a picture of what he has to do, not just a reading of text. He says at paragraph 20, we quoted paragraph 41, that this court enjoys the exclusive jurisdiction to decide a failure by the president to fulfill his obligations ought to not be surprising, considering the magnitude and vital importance of his responsibilities. The president is the head of state and head of the national executive. His is indeed the highest calling to the highest office in the land. He is the first citizen of this country and occupies a position indispensable for the effective governance of our democratic country. We underline this. Only upon him has the constitutional obligation to uphold, defend, and respect the Constitution as the supreme law of the Republic been expressly imposed. The promotion of national unity and reconciliation falls squarely on his shoulders. Unity, as does the maintenance of orderliness, peace, stability, and devotion to the well-being of the Republic and all of its people. Whoever and whatever poses a threat to our sovereignty, peace, and prosperity, he must fight. To him is the executive authority of the entire Republic primarily entrusted. And then further down it says, and almost all the key role players in the realization of our constitutional vision and the aspirations of all our people are appointed and may ultimately be removed by him. Unsurprisingly, the nation pins its hopes on him to steer the country in the right direction and accelerate our journey towards a peaceful, just, and prosperous destination that all other progress-driven nations strive towards on a daily basis. He is a constitutional being by design, a national pathfinder, the quintessential commander-in-chief of state affairs, and the personification of this nation's constitutional project. What is our constitutional project? To keep our multi-party democracy vibrant and alive. And that's precisely what he does in his speech, to meet those obligations. And we submit that when he encourages voters to vote to secure a better future for our country, he does exactly what the Constitution requires him to do. Yes, and diversity must never be lost, because when he is talking about diversity, he acknowledges the plurality of views and political opinions, and that we vote indifferently. He's not calling on all of us to just vote for the ANC. So we submit, when one looks at the proper interpretation of that section, abusing office to influence the outcome, the conduct or outcome of the elections. Conduct, the mechanics, outcome, the result. At best, he's saying the result must be a multi-party democracy if we vote. He's not saying the result is the ANC administration because I'm calling on you to vote for the ANC. He's not doing any of the sort. So we would submit that on a proper interpretation of the two provisions, even before the court grapples with the speech, the content, context, words used, they just don't come home. The second point about the interpretation is whether it's not just meaning, is whether the provisions impose strict liability without the requirement for fault. And we submit that the Constitutional Court judgment in the DA versus the ANC, that at paragraph 159 of the judgment, which we handed up, you will see that it cautions, so you'll see from paragraph 154, and my learned friend Mr. Kasim read paragraph 154. From paragraph 154, it discusses the presumption against strict liability, which is one of the guidelines that the court must take into account in interpreting the legislation. But importantly, at paragraph 159, this is what the court says. In that case, the claim was for a mandatory interdict and not for a penalty as here. And what the court said at 159 is this does not, however, impact directly on the relief sought in the kind of case that we're dealing with here. The ANC sought mandatory relief aimed at preventing further prejudice to it from the alleged wrong committed by the DA. The relief sought was akin to that sought in a mandatory interdict, where positive conduct on the part of the alleged wrongdoer is required to determine continuing wrongfulness. In those circumstances, fault is not a requirement for the grant of an interdict. We caution, however, that when criminal liability and the imposition of the severe civil penalties under the Act are sought to be enforced, the issue of fault will become crucial. And so the court says, if you come into court under the civil court and you're asking for a penalty of a fine, fault is important. And fault would either be intention or negligence. And one would, if you're dealing with a criminal setting, the standard might be different, but if you're looking at a civil setting, you would have to allege and prove fault on a balance, allege and prove fault either as intention or negligence. But what you have here is an application that did not allege any fault on the part of the president, either by way of intention or by way of negligence. So they accept what he says is the reason he made the speech. They don't say he always intended to promote the ANC. They say you must infer from what he says that he was intending to promote the ANC, but they never really allege fault, because also if you rely on fault as negligence, you would have to say what a reasonable person in the position of the president would have, how he would have acted and how he fell short of that standard. That's how negligence is determined, but that's not the case that we were called to meet. You don't find that in the founding affidavit at all. And that approach that there is no strict liability, there is fault requirement. In fact, the way the DA came to court is if you can interpret the speech as crossing the line, so to speak, as they say, offside, he's strictly liable. It doesn't matter that there may or may not be fault, because they don't plead that, they don't allege that. They're simply saying halfway through the speech he slipped and started getting offside, and that is enough for purposes of a contravention and for the imposition of a fine of 200,000 rand. And what the Democratic Alliance with ANC in that paragraph 159 says no. Where you are asking for the civil penalties, you want them imposed and enforced, then fault is crucial. And this was further discussed in this division by Dipenar J. In Brown versus Economic Freedom Fighters. We've handed up that judgment to the court, and that it's paragraph 49 of that judgment. At paragraph 49 of that judgment, the court deals with the question of fault, and if the court has that paragraph, it says, as stated by the Constitutional Court in Democratic Alliance versus African National Congress, these are tough provisions which could operate with calamitous effect on a person or party who falls foul of them. In case of doubt, the prohibitions are to be interpreted restrictively. Any ambivalence or uncertainty about their meaning must be resolved in favor of liberty. There is further an interpretive presumption that a penal provision includes a requirement of fault unless there are clear and convincing indications to the contrary. The Constitutional Court further cautioned that where criminal liability and the imposition of the severe penalties under the Act are sought to be enforced, the issue of fault would become crucial. I accept that for present purposes, fault is a requirement and strict liability is excluded. And the court was referring to Section 94. which enforces the code. And one can't read 87.1G and 9.2E as excluding fault in circumstances where the political campaign by a political party, where you're using public funds, the use of public funds can be inadvertent. In other words, the president can't unknowingly use public funds if those funds are meant to fund a political campaign.
Yes.
And the same thing, when he abuses his office to benefit the outcome of elections in favor of his party, it can't be unknowing by the president, if that is what he's setting out to do. So we submit with respect that it is a requirement to get those civil penalties imposed, such as the 200,000 rand fine, that there must be fault demonstrated, but that's not alleged at all. And
Well, I mean, it seems to me though, Mr. Manager, that fault is alleged in the founding affidavit, but it's now being stepped back from because now they're saying we're not taking issue with the bona fides of the president in his answering affidavit. So now we're using the objective test because the founding affidavit is replete with allegations of thinly veiled and masquerading and sought to. That's all deliberate.
yes,
Those are allegations of fault
yes,
and intention.
yes.
So there are certainly allegations of fault in the founding affidavit.
Yes. So they step him back because it can't square with the content of the speech and the context of the speech. You can't show that he intended to masquerade as giving a speech to assure the nation and to encourage people to vote, when in fact this was a political campaign for the ANC. You can't find that in the context and in the content of the speech. So to the extent that they allege some kind of scheming by the president, intentional scheming, and they're stepping back from that, we submit is because that is not supported by the context that is uncontested in the answering affidavit and the content of the speech.
Well, the bona fides of the president would not be something that would be required where strict liability is a requirement, because obviously. But if fault is required, then bona fides of the president, if you accept that the president was bona fide, then there is no basis upon which one can say the president had the intention to abuse the public funds or to campaign for the
Yes.
ANC.
Yeah, precisely. Let's just go back. I couldn't say it any better than that, Justice Ondi. But if we just go back to what Justice Yakub indicated earlier, that the founding affidavit is replete with this kind of question in the bona fides of the president. If you look at page 18 of the founding affidavit, and this is addressing the conclusion which I read to the court already, the conclusion in the speech. You look at paragraph 26 and what the DA says at paragraph 27 and 28. At 26 it says, the conclusion of the speech reveals its purpose. It is appropriate to quote it in full, but you will see that this is not a quotation of the conclusion in full, because it leaves out a number. It says, fellow South Africans, the last 5 years have been a time of rebuilding and recovery. It has been about working together not only to meet the challenges of the moment, but to put in place firm foundations for a better future. As this sixth administration draws to a close, and as we prepare for the seventh administration, then they highlight, let us build on the progress that we made. And then at this moment in our path to renewal, we cannot afford to turn back. There is more work to be done. Let us draw strength and encouragement from the difficulties we have overcome together. Now, what you will notice immediately is that is not a full. They say they are quoting the conclusion in full, but that's not the conclusion in full. They have left out from the address let me just highlight for the court what they've left out. So they stopped at, let us draw from, when you go to page 35 of the speech, let us draw strength and encouragement from the difficulties we have overcome together. It leaves out, just below that, I call upon all South Africans to go cast their votes. We are a diverse people but a united nation. Let us be united in our commitment to our democracy. Let us work together to build a better country. May God bless Africa. So they leave out those things in their quotation. And then having left out those important parts of the conclusion, in 27 they give their own interpretation of his conclusion. They say, these statements reveal that the purpose of the address was solely to solicit votes for the ANC. Mr. Ramaphosa is saying that voting for a different party and therefore a different administration will undermine the supposed progress his administration has made. The language of renewal is exactly the same language the ANC has repeatedly used in its electioneering. In his ANC speech, Mr. Ramaphosa said, we had asked him that on the 29th of May, you vote for the democratic renewal. 28, it is unclear why the president would feel the need to talk about the work of his government 4 days before an election, other than to seek to persuade voters. That's their interpretation from the conclusion. Having omitted the important parts, calling on all of us to vote, they give it this spin at paragraph 27. You can see this is really, this politician speaking. This is not what the speech says. It is not saying, if you don't vote the ANC, there's going to be loss of gains already made. That's not what the speech says. But that's what the deponent says. That's what the speech says. And that would not reveal, that conclusion does not reveal the things they say it reveals, and the intention they say he harbored and schemed to use his office, abusing the office to benefit the ANC. Then, my lords and my lady, in the context of that interpretation and what I've addressed, our submission is this case ought to be dismissed simply at the level of the framing of the case as against the provisions properly interpreted. But then we do also address the President's address itself. And we do that at paragraphs 65 to 95 of our heads at page 24. I'm not going to go through chapter and verse what we say. We say a lot, but I'll just draw it together to illustrate what we really say. So we say, firstly, the same principles of interpretation apply to interpreting the speech, because you're talking about the language used, context, and purpose. And here the court must be careful to be drawn into using defamation case law. My learned friend talked about Day versus the other case. Leroux versus Day. Now, you will see in the ANC, in the DA versus the ANC, the majority judgment actually said the SCA was not correct to be looking to defamation cases to give meaning to this statute. What the enterprise that the court is required to engage in when you are asked to find the contravention is to interpret their provisions, not to look at how defamation talks about how ordinary people look at this, at statements made. And here, the fortunate part is you're not asked to re-listen to the statement, you're given it on paper. So you interpret it using the statutory, the rules of interpretation, where the words are the point of departure. You read the speech as a whole, you don't cut out, you don't look through the speech and isolate a sentence and say, but that one can benefit the ANC. So that point about 90% versus 10%.
Yeah.
The prohibition is not about the speech incidentally is a political campaign, or the speech is incidentally may benefit the ANC. The speech is an abuse. It's designed to abuse the office for the benefit of the ANC. The speech is a political campaign, as in it is in respect of the political activities of the party to benefit that party in elections. You don't punish somebody that you did very good in line with the law, but incidentally something might not fall within the strict contours of your powers. This offside issue. This offside is, the goal is allowed. So the president is not offside, with respect. And the context and purpose appear in the speech itself and also in the president's answering affidavit.
So the key is that in the word abuse.
Yes.
It's not in the word influence. Because if by the very fact of my existence, I influence you to do something, that's neither here nor there.
No.
You thought I was a good president, so you're going to keep voting for my party. That's my influence.
Yeah.
That's irrelevant.
Yeah.
It's if I use that, if I abuse that.
Yes. That's the conduct that's
To
prohibited.
influence.
Yes.
It's the abuse that's
Yes.
the key.
So it's the conduct and the result. There must be a causal link, but the conduct is the abuse.
Yeah.
It's not, so if there's no abuse, but there's influence, that's not a contravention. There must be an abuse and there must be an influence. There must be a result. And at the level of influence, all that the DA can say is that it would have convinced some people who may be sitting on the fence to vote for the ANC. They can't say, there's no evidence of the influence. He said the same thing they say on their version.
Sorry, Mr. Manager. There's
Yes.
something that I think that I'm not following you. You say there must be a connection between the abuse and the influence.
Yes.
But how do you do that? How do you determine whether or not the abuse by the president influenced the outcome of the election?
Let's take an extreme case where the president bought food parcels,
Yeah.
went to a village. They used to do this in the homelands. When the homeland governments were up for elections, the chief minister would invite all of us who didn't have food and they slaughter a cow using public funds. And people vote for
those
them.
are clear-cut cases.
Exactly. So in the difficult case,
Yes.
bearing in mind the constitutional court injunction that you must approach this restrictively, when there is ambivalence or doubt in those marginal cases, you
Yes.
interpret it in favor of no contravention, no penalty.
In other words, there will be some cases where it will be difficult to determine whether or not the abuse resulted in influencing the outcome of the election.
Yes. Sometimes,
How do you quantify?
sometimes it might be the extent of the abuse might suggest that this, in the ordinary course, would have that outcome. Where monies are given out or people are promised jobs, those stuck cases, it might be hard to say, well, it had no influence because it's so egregious, so clear, the abuse, and the extent of it is likely to be influential. The is likely to have that, cumulatively have that effect. But here you are now in the marginal one where even deciding whether it's an abuse itself is a problematic.
No,
And
we're dealing with a grey area here.
we're dealing with a grey area. On the influence, there is no scintilla of evidence that there might have been an influence. And one must think, they claim that the president made the same claims on Friday
The 25th.
as Siyangoba,
Well, yeah.
which
the
he
day
made on
before.
Sunday. So is what's the word? Is doing the same thing, according to them, doing the same thing, hoping for a different result. If it didn't work on Friday, how did it work on Sunday? When he doesn't even say what their plans are on Sunday. He's simply talking about what, as a collective, we've achieved. So even on the causal connection, there is so much grayness on the influence in the outcome. Influence in the conduct is clear, there's none. But as we submit, they can't even come home on abuse. And bearing in mind the fourth requirement. So as regard to context and purpose, it's the content of the speech, but it's also what the president explains in his answering affidavit, which is can't be disputed and must be accepted on plusquam evidence. And I've already referred to the purpose when I took the court to the paragraph 63 and the following of the speech. And then we say, in summary, in respect of the speech, it is common cause that the trigger for the president's address was the security concerns. It's accepted. And the DA says, if all he did was stand up and say, there are security concerns, there will be sufficient police, go and vote, they wouldn't be in court. They only complained because he then said, I want to encourage people to go and vote, and I'll do so by reminding them about the challenges that face the country and that we overcame them, and that to secure a better future, we need to vote. They say that's stepping out of line. We say no. The Constitutional Court says the president is the pathfinder. He's the one that must steer us towards a better future. One might disagree with his conception of how that better future looks. He said that better future is a diverse population that's united with a multi-party democracy. Go and vote. And it's also common cause that he acted on advice of his advisors to assure the nation that the elections would be peaceful and secure despite the concerns, and that sufficient measures were in place to ensure this. So it's not a president who was sitting with ANC strategists. He's sitting with his advisors, and the court must assume that those advisors are faithful to the jobs they perform. They are advising the president to perform his functions. In fact, it's in Van Rooyen judgment, the Constitutional Court judgment in State v. Van Rooyen dealing with the magistracy. And the argument was a provision of a statute was so broad that it would allow abuse. And the court emphasized, I think paragraph 37 of the judgment, that you must assume that a functionary would perform their function in accordance with the law. If they don't, you can take them to court for review. But you don't proceed on the assumption that they're not performing their work properly. So he acted on advice. And even the IEC and the NUT joints had highlighted the concerns. It was reasonable for him to deal with them. And he, with his advisors, they deliberated on the method and the form of address and agreed on the family meeting mode of address because we're all accustomed to it. He's now not going to suddenly use all those 38 addresses with the same theme, suddenly really deceive all of us and campaign for the ANC. One needs to have a very suspicious mind to reach that conclusion. And the ordinary listener and reader is the one that does not have a suspicious mind. One that is not a surgeon cutting out words and putting them here and there and interpreting. You get the message holistically. And I said, he chose to speak about the path we've traveled together in the last 5 years. And it's clear he reminding South Africans, we don't want to regress from that path. It's a good path. Let's carry on it. True to his purpose, the speech is really, I circled everywhere he talks about we, South Africans, as a collective, institutions of South Africa. You will find it is a lot, together as a nation, you will find a lot of those. I have lots of circles here. If I was marking a script, this student would probably fail. But it's an indication of the target of his speech was all of us, not ANC supporters. And then not once does the president refer to plans for the 7th administration, that he might become part of that administration, or that plans of the ANC to deal in future with any challenges in respect of that administration, which is what typical of a political campaign. And I've already contrasted that with the manifesto of the DA. His call in conclusion was not that South Africans must vote for him or vote for the ANC, was for the South Africans to go and vote for our country's future. He emphasized our diversity and unity, our commitment to our democracy, and the need to work together to build a better country. He does not once say that he or the ANC are the ones that can build a better country or a better future, which is what he said on Friday, because that was a campaign for the ANC. It is a message to assure South Africans that elections will be peaceful and free. It is a unity message and a reminder of the importance of our democracy. He reminded South Africans to vote and to keep what the founding fathers and mothers bestowed on us, which is a multi-party democracy. In contrast, you will see I've referred you to the clear misinterpretations by the deponent to the DA's founding affidavit, Ms. Zille, at paragraphs 26 to 28 as to what the clarion call was here. He said it was to vote for the ANC. So we submit that on statutory interpretation, on a proper interpretation of the statement, which is of course objective, but using the tools for statutory interpretation, there is no contravention and there's no issue about penalty. And there's no declarator that should be given, and there is no penalty to be given. But we made the submission also in relation to penalty. You will find that at paragraphs 102 to 108 of our heads, that other than the declarator, the other penalties are not justified. The DA asked for 200,000 rand. It has now accepted that it can ask for the 1% deduction. It does so after saying to the court candidly, we accept the bona fides of the president. Why do you need a fine to deter what? Because the president...
Well, in the light of the recent development that there is now a government of national unity in place, that remedy of seeking a deduction of 1% of the vote cast for the ANC, how is it going to change the situation in Parliament?
I don't know. I mean, it might bring in one of the ones they don't want.
Because that's how I see it.
Yes.
You deduct,
it might upset
1%, and what happens at the end of the day
exactly.
now? Because those seats are forfeited.
Absolutely. The court can ask a rhetorical question. Why is this case before the court? If the DA comes here and says they accept the president's bona fides, and they're sitting on the table on a government of national unity, is this a genuine legal case? And we submit that it is on the facts and on the law, it is really so weak one can risk saying it is a frivolous case. And we submit that it should simply be dismissed out of hand. As far as costs are concerned, we ask for costs, but we're mindful of the Bauer's principle. But the Bauer's principle is not a complete shield. It's how do you conduct the case? Is this a case that should be before the court?
Well, but we can't say the manner in which they have conducted this case is vexatious or frivolous.
Well, I accept. It borders. That's all I can say. I can't say that with a straight face, my lady. But we submit that the application should be dismissed, and subject to Bauer, we ask for costs of 2 kinds.
Mr. Stein, we have had a debate between... Sorry.
Mr. Ngongo has the citation for State versus Van Rooyen, if you
okay,
would like.
Sure.
It's State versus Van Rooyen and others.
1998.
I can give the SA law report citation. It's 2002, volume 5, SA 246, and is a judgment of the Constitutional Court. I just quickly check whether my reference to paragraph, I might have not referred to the right paragraph, but I will. Yeah, so it says 37. Yes, it is the right one about the fact that a provision is capable of abuse is not a basis to invalidate it.
Paragraph, you said paragraph
37. And I can't recall whether it's before this or after that one must approach the matter on the basis that the executive would exercise their powers properly, and if they don't, you can review it. Yeah, this here was really to say that the magistracy was almost the personal fiefdom of the minister. That's what they've been argued in the High Court and upheld. And the court says you can't assume that there will be an abuse, basically. There was no factual basis for that finding. So we submit with respect that this is an application that should be dismissed. If you don't find in our favor on jurisdiction and you go to the merits.
Just one thing, I mean, Mr. Stein took issue with the use of the word renewal.
Yes.
And, the theme of unity and renewal, because that was something that was highlighted in the Siyamoba address as well. Are we to make something of that? I mean, I don't think you've addressed that particular thematic commonality.
Yes. There is a discussion in the answering affidavit of the general themes that he has repeated over the 38 speeches that he's given. And I stand corrected, but the concept of renewal would have been something that was said as it may have been that the president would have said to the country, we are tackling corruption as a party, we're on the path of renewal in different contexts. But a renewal for a country, the concept of renewal is not strange where it's used by reference to the country or to South Africans as opposed to the ANC's program of renewal. That as a country post-COVID, we had to rebuild and to renew in relation to the economy, in relation to so many other things. The floods, the setbacks, you have to rebuild. There's so many areas in which we constantly have to rebuild. Even job creation, we are in a rebuilding mode, at least since COVID. So why can't the president talk about renewal in a sense applicable to us as a country? That's perfectly legitimate. The fact that incidentally it was said by the ANC, it also doesn't mean the DA doesn't use it, or the EFF doesn't use it, or so many other political parties. There's nothing exclusive in the concept of renewal in relation to the ANC. It's a concept that's very appropriate to use in this SA context, economically and otherwise, about where we are. And especially when contrasted against the challenges we've faced. And one would have seen in the last 2 months when they report on unemployment rates, and you have provinces that go over 40% of unemployment. We're constantly rebuilding. So we submit.
You have said you have to vote to rescue us or to save us from falling backwards.
Yes, that's the DA.
I know, but he could have said that, but he didn't. He
Yeah.
chose to use the same words that the ANC used, and I assume that's the core of the campaign.
But in the question my lady poses, there is an answer.
Yes.
Because he says, the question is, he could have said, vote for us so we don't go backwards. But he never once says, vote for us. It's not a campaign. And he could rightly have used, instead of renewal, he could have said, let's rebuild. There's rebuild in the speech anyway.
Yeah, I see.
So he just used different ways that mean same things.
But
The idea
sorry,
is,
Mr. Madman,
yes.
can you just refer us to the passage in the speech where he uses the word renewal and
yes.
see in what context
Exactly.
that
If my recollection is in the conclusion,
Yeah.
the concluding remarks. Sorry.
was it might assist us and
Yes, quite. So,
Page 35.
yeah, he says
At this moment in our path to renewal.
we cannot afford to turn back. At this moment in our path to renewal, we cannot afford to turn back.
But before that, he also says it's about working. It has been about working together.
Yes, yes.
And then when you look at the speech, the ANC speech, he talks about, that's on 58, we are asking that on 29 May you vote for democratic renewal, national rejuvenation,
Yeah.
and socio-economic transformation agenda to continue.
Yes. If a South African has been a faithful watcher of those family meetings, you will see that this president has a particular liking to use particular words,
Yes.
which he uses repeatedly,
Yes.
like uniting. If you wrote his affidavit, you could pretty much use those words because that's his language. So it's the same person speaking. It's splitting hairs to say, if he meant renewal as a country, he should have used a different word. Because he uses a word that is incidentally used in an ANC election campaign, he's continuing the campaign of Siyanqoba. It's really taking that word out of context. And that's a contextual reading of the statement as a whole.
And we have one other question, and it's completely irrelevant.
Yes.
For this family meeting, was he at least on time?
I think he was on time. I don't recall, but I don't put my head on the block, but I think he might have been on time. As the court pleases. He generally is on time. As the court pleases.
Mr. Stein, you had a debate between the bench and Mr. Manager and Mr. Carson. Now it's your time to reply. What do you want to say in reply?
Yes, and indeed, my lord, I've obviously listened to the debate and I don't want to rehearse arguments. I'm going to make 7 points in reply with the court's leave, and I hope to be relatively brief. But it is important that I correct certain things and clarify the submissions in that regard. Let me begin with jurisdiction. You've heard our submissions of jurisdiction. The court has jurisdiction. The question is whether we can approach as a court of first instance. The court has the jurisdiction to entertain these matters. The court does not prescribe the manner in which leave is sought. It's a complete distortion to say that the case was made out in reply. What happened is that the jurisdiction point was raised by one of the respondents in their answering affidavit. The response was, we then seek the leave of the court and we rely on the facts. The factual basis for it we rely on is set out in our founding affidavit. We don't then attempt to make out a case for that leave in reply. So we say, and that was out of an abundance of caution, so we say on either leg, with respect, we should come home on jurisdiction, and that's in addition to the fact that the court has had the benefit of full argument, as was the case in the Reddy case. It would be surprising if those resources would have to be repeated before another court and hearing the matter. Then the second argument that I must address the court on is the heavy reliance on the case of the DA versus the ANC. And I do ask the court to go and consider the judgment, because what has been relied upon, what we take from that judgment are two very different things. The first point that clearly emerges from the DA versus ANC case that's been relied upon is that the approach to the interpretation of the speech, the approach that the court applied to the interpretation of speech there it was an SMS, here obviously it's an oral speech, although it was also produced in written form. The approach was unequivocal and unanimous, and that was an objective approach. The court said, and it's at paragraphs 96 to 98 of that judgment, I'm not going to delay you by taking to you, that the proper way of interpreting it is to look at it through the eyes of the reasonable bystander, the reasonable person. We would say in this context it's the eyes of a reasonable potential voter, a reasonable member of the electorate. How would they interpret the words, the speech that was given? That's at paragraphs 96 to 98, and it's a decision of the Constitutional Court. Yes, paragraphs 96 to 98. I can take the court to it if it would be beneficial to do that. Just catching up with my computer. So in this case, it's interpreting the wording of the SMS, and the court, it refers to authority, and the court says, on this test, the applicable SMS is an allegation of fact that's considering whether it was a question of fact or an opinion. An ordinary reasonable reader of the SMS would not subject to the same scrutiny to which a lawyer or professor or judge would. Refers to Williamson Jay's judgment in Dorfman. The test is certainly not how a trained lawyer, after an astute and careful analysis of the words, might understand the article, nor how any superficial reader might read it. An ordinary reasonable reader, listener in this case, or reader if they're reading it in written form, would perceive the SMS as saying, and then they go on to say what it is. So it's quite clear in our submission that the test that the court applies to the way that the message is received is the test of the ordinary reasonable observer, and the court is astute to traverse that.
That was the minority judgment.
That was the but both court. This is the Cameron judgment that my learned friends have.
96 to 98 is the
It's
Zondo
Zondo judgment.
That is so actually. But the approach,
But
as I understand, I don't think that the majority took issue on that aspect of it. If I stand to be corrected, but on the way it is, on the way the message is to be received, I don't think there was a difference in the court on that issue. And indeed that's precisely the paragraphs that my learned friends rely on for the statement that the test is one of a reasonable observer. The minority and the majority did not differ from one another on that point. The second important aspect of it is that it dealt with Section 89 of the Act. And it's in that context that it's critical to have regard to the judgment and to what is said about fault. If one looks at Section, and it's careful to distinguish Section 89 from the other provisions of the Act, and I believe that Lady Justice Jacob is anticipating what I'm going to say. What is clear there in Section 89 is it's expressed in Section 89 that the test is one of intention. The heading is intentional false statements, and in sub 1, the test is the provision is no person, when required in terms of the Act to make a statement and makes it express, must make a statement knowing that it is false without believing or on reasonable grounds that the statement is true. That the Act articulates the test, and then the debate in the court was whether or not, because it isn't articulated in sub 2 for the purposes of the test of a violation in sub 2, whether one should apply a standard of strict liability or whether one must impute some fault element. And the court rightly said, well, we can't, you're reluctant to impute strict liability in any case where there's a code, as my learned friend says, so it goes back to interpret it in light of sub 1. But of course the critical aspect is that we are not dealing with the same provision. And in fact, the very, you will anticipate what I'm about to say, the very fact that the legislature, where it requires the test to be one of strict intention, has expressly stated so, suggests strongly that where it doesn't say so, the test is not one.
So strict intention.
Yes, well, intention, deliberate intention.
Oh,
so
yeah, okay.
knowing that it is false.
Sure.
So the legislature here says intentional false statements, and then has set out what those statements are.
That's Section 89.
That's 89, exactly.
Yes.
Whereas you don't have the same, of course, in Section 87, which is what the provision that we're dealing with. So at no stage has it been argued that the test is one of strict liability. But the question then for the court will be, well, what standard of fault does one apply if it's to be a standard of fault? And of course, there is more than one option. What we are saying is that the standard of fault is not just one of intention, but also one of reasonableness, what we would regard in other contexts as negligence. And that is a sufficient basis upon which to come home on a breach of the code. If the conduct of the president has not reasonably met that standard, then it would be sufficient. And that's in stark contrast with Section 89, because 89 specifically provides for the elements of intention that are required, whereas Section 87 does not do so. So we would say that the appropriate standard, having regard to the purpose of the code, cannot be one of intention in the ordinary sense. It must be an expansive definition of fault that includes a reasonableness standard. And it is through the prism of that that one must assess the evidence in the case, but particularly the President's say-so. Was it the standard? Did the President meet the standard of a reasonable person in that position when having to know the requirements of the code, knowing what the obligations are? That would be the definition that we would urge upon.
Sorry, I'm not clear. The reasonable standard now said the reasonable standard is a test to determine whether the statement is violated the code of good conduct.
Whether there's been a
The
breach.
test is a reasonable
Yes,
standard test.
that is the submission.
What does it entail, the test that
Whether a reasonable person, my lord, in the position of the President, having regard to the code, or if it's another candidate in the position of that candidate, would understand the provisions, would have expressed themselves in that way, would have conducted themselves in that way. The test is not whether the President deliberately intended to do so.
So in other words, it's fault in the form of negligence.
That's exactly the way that we would put it.
Now, but what about the fact here that the remedy that is sought and the order that can be imposed is the order that involves the imposition of the penalty? Does that have any effect on the task that we have just postulated?
Well,
Or it doesn't matter?
I can
As long
only...
as it-
I'm sorry, my lord. I'm
No,
sorry.
no, okay.
I can only go as far as the
Yes.
court in the DA case says, and that is to say it shouldn't be strict liability. The presumption is against strict liability,
Yes.
so it must be an element of
There
fault.
must be some fault
We
of
must
some kind.
interpret each provision on its own terms.
Okay.
And so the court may find, for example, that in respect of certain things there should be intention because it's silent, but in others there is a more expansive requirement of fault, including, as your lordship has put it, negligence. And we would say that is indeed the case in respect of 87, and for two reasons. One, the express wording, where the legislature has intended intention to be the test, rather than a wider fault requirement, then it has said so expressly in this very act, and that, as we know, is a very strong indication, but also having regard to the purposes of the act. The purposes, as I began my address initially, of the act is specifically to prevent those fundamental principles from occurring, a blurring of the line between the public role of officials and their private political role, or their role when they wear their political hats. And we say in that case it wouldn't be serving those purposes if one required an intention test. I was going to lapse again into strict intention. What would happen there one would set the threshold for breaches of the code so high that where there is a charge, and this happens all the time for the Commission against parties and parties in favour of other parties, the mere defence of saying, well, I didn't intend it, it wasn't intended that I breached the code, would be sufficient to demonstrate that there was a defence to an allegation of a breach of a code. That, in our submission, would be a very, very low threshold for a defence, and it wouldn't serve the purposes of the Act. The Act, we would say, must import a standard of reasonableness into the test for fault.
In other words, he ought to have foreseen it.
Exactly, my lord. Exactly. So, and that's where the debate has become a bit blurred, and that's what is important in reply to clarify. There's no argument for a strict liability standard. The argument is what is the test on DA versus ANC, what is the test for fault that should be applied? And it's clear why in DA versus ANC under Section 89 they applied, the Constitutional Court applied the intention because it expressly provides for that. And the court has said that we don't easily presume strict liability. But that's not the case, and the court said so expressly in respect of other provisions. The other provisions must be interpreted on their own terms, and that's our submission to the court. third I'm sorry, just to return to that theme. Of course, there is also a distinction then between the civil, and I understood it to be conceded by my learned friend in his address, between the civil sanction or penalty that is imposed and a criminal sanction that is imposed. That engages what your ladyship indicated was really that we would agree is that the test for the standard. What would the standard by which you have to prove that those elements, including if it were fault, whatever the element of fault was. But we are dealing in this case with the civil sanction, not with the criminal sanction. And the Act again makes very clear that there is a strong distinction between the two, because in Section 96.3 it says any penalty or sanction provided for in this section will be in addition to any penalty provided for in Part 3 of this chapter. And then it goes on to provide for offences. So it says any person who contravenes a provision of Part A of this chapter, or provision of 107, 108, or 109, is guilty of an offence. So that's over and above the civil transgression, let's put it that way, or the civil. And then it provides for the conviction standard, and that's...
But as I understand it, that's simply to make it clear that there's no such thing as an argument of double jeopardy. You can be in for both.
You can be in for both, but we would strongly submit that the criminal standard would apply there, as your ladyship suggested.
Yes,
whatever,
but it's the same breach.
Whatever the court finds regarding the elements, whatever, for example, the element of fault is in that case, a different standard is likely to apply in the criminal context than in the civil context. There it will be a balance of probabilities, for example. It will not, for example.
No,
it will be a balance. Whereas in the criminal context, it hasn't been decided, and it is not an issue in this case, but it's likely to be a criminal standard. But that is a separate question from the nature of fault that is required for the coming home under a breach of the code. Yes. That's the only point that I made. Then briefly on the interpretive issues.
This is now the third point.
This is the third point, indeed. My learned friend urged on your court a very narrow definition of the meaning of political campaign and reached for the Public Funding Act, can I call it that for short, to assist in the definition. But firstly, we suggest to the court that that definition in the Public Funding Act is a wide definition. It incorporates all sorts of political activity, as my learned friend read out, and I'm not going to repeat it. That would constitute a political campaign. And we would say that takes on particular meaning in the context of an electoral period, which is precisely what is the situation here in the matter that's before this court.
But what would constitute political campaign?
A political...
In general, because I mean it's a concept that is not defined in the Act, is that not so?
That is correct.
Okay.
And
so, in the absence of a statutory definition, then we are left with what?
well,
There must be something to guide us.
yes, and we are quite happy with the court to be guided
Yes.
by the Public Funding Act, which we suggest to the court is a particularly wide definition, actually, of political campaigning. But in essence, it must involve the promotion of one's political policies and ideas. That is what political campaigning is. One advocates for one's political standpoint. So I think one can provide a common sense approach to it, or a ordinary meaning approach to the word campaigning.
So it's less than saying vote for us.
It's it's saying vote for us for these reasons. These are the reasons that we've done this and this and this, or we advocate these policies. That is how political.
That necessarily includes vote for us.
It doesn't. Well, that's very important, because if it's clear in the context, and as my learned friend says to you, context is important. If it's clear that what you're saying is, we recommend to you everything that we have done, look how well we've done, then the clear implication for that is vote for us. It doesn't have to expressly say vote for us to say that. There may often be cases where it doesn't expressly say vote for us. And we would say, in this case, in the context in which it's presented, there is a strong advocacy. And in fact, it goes even further than that. It says, let us stick to this path. Let us stay on this path. That is an advocacy for sticking to the policies that are outlined. And that is more than sufficient, we would say. Although we accept that there would be a twilight area, of course there would be, but this is well within the sphere of what, even under the Public Funding Act, would constitute political campaigning. Because one would be saying, we recommend to you all of these things that we have done, that we have achieved, and we should stick to this going forward. That is the very essence of a political campaign.
I think right at the beginning of the question, you said that it's to promote your political party. I think that more or less sums it up, because implicit in that, why else would you be promoting your political party if you're not expecting people to vote for you? I think that more or less sums it up. A political campaign, in the normal sense, means promoting your political party.
Political party or ideology, your political ideology. So you wouldn't have to say by name that this is the party, but if you advocate the principles that that party has publicized and stands by, that would constitute political campaigning.
And if those principles include multi-party democracy, universal suffrage, freedom of speech, equality, dignity.
I'm sorry, Justice Jacob, all of those fall firmly on the no offside line, because those are in line with the constitutional objectives of the president. Exactly.
And he's obliged to further that and defend it.
Absolutely, but the following don't, and at the risk, I did exactly the same as my learned friend. I went and circled all the cases of we, and we provided support to 1,000 black industrialists. We have worked across government with NGOs to implement the presidential employment stimulus. We increased the number of police on the street. We worked together to implement the national minimum wage. We doubled the number of students receiving NASFAS. All of those we's cannot, on our submission, on our firm submission, be understood by a reasonable observer to mean anything else than we, the administration, which is undertaking the program of the party for which we stand, have done all of these things. That administration for which I stand for. And what is absolutely crucial, and I must, in favor of my client, make this submission. One has to realize that those advocacies for those policies or those achievements, those political achievements that have been made, are made on the eve of the election, when all other electioneering is stopped. By law, no other party now is allowed to advocate for their achievements or their political policies. One must ask, how would an ordinary person situated in political opposition to the president's party, and of course the president is free at the time when other candidates are allowed to advocate for his policy, how would an ordinary reasonable observer who does not share the same vision of the achievements of the president understand those remarks?
But some of the things which he said, surely your client will agree with him. Is that not so?
Well,
you mentioned about 5 issues when you started.
Well, these take up a good 7 6 pages of a 10. I don't want to get into the dividing of the pie, and I've made the principled submission that if the President is offside in respect of one of those utterances, that is a violation of the Code, and that we make the submission in accordance with the Code. If one of the utterances was sufficient, but I've listed just now, and I haven't exhaustively done so, we did it previously and we've done it in our heads, that there are many more than that. This was 6 or 7, and in each case it was unequivocally, and we would say on any reasonable interpretation, these were statements about the achievements of the ANC government. That is the President's administration. And of course one would never take issue with those achievements in the context of a party political rally or context. But the nub of this case is that these were uttered from the presidential, I hesitate to use the word pulpit, the presidential platform, expressly under the guise of the President, while the President was making important presidential statements to the nation. They were included. They were particularly advocated using that platform, and crucially at a time when no other party is allowed to do so. So the President is allowed the last word on his own political policies and his own political achievements.
Well, I think that Mr. Stephen,
Yes, indeed.
Another point.
Yes, indeed. So the first point we make is that political campaigning is wide, and even under the Public Funding Act it is a wide definition, but we would say that it promotes, wherever you are promoting your political objectives and your policies, that is political campaigning. And it applies with greater force in the context of an election, where everybody is campaigning, contesting ideas. Secondly, in respect of the code, that is item 9.2e, my learned friends concede now that this is an exercise of power as understood by that provision. They've always accepted it, I'm told, but anyway, it's accepted that this is an exercise of presidential power. But they pause by saying that there must be some element of causation between the abuse and the influence. Now, if that is the test, if it's a test of strict causation that is going to be inferred there, then one will never be able to demonstrate an influence on the outcome of elections, or on elections, or on the conduct of elections as provided for in that provision. So if that is the bar that this court is going to set for the requirements of item 9.2e, that is a bar that would be too high to reach in almost all cases. One is not going to be in a position to prove that the particular exercise of power influenced the outcome of elections. One would only begin to wonder what kind of evidence would be required to demonstrate that. We would say that the clear intention of the legislature in this regard is to indicate that on a balance of probabilities, in view of the exercise of the power concerned, would it reasonably be likely to have the effect of influencing either the conduct or the elections themselves? And we would say it's clear that in the context of an election campaign, when one uses the presidential platform in this way, that it would have this effect on the outcome. It's not a test of strict causation as is suggested. That would
okay, let me see if I understand your submission correctly. So you are saying that what is important is the effect of the abuse, not the causation. You don't have to establish a causal link between the abuse and the outcome of the election.
Yes, it would be the fact of the abuse in the context, having regard to those circumstances. Would that be likely to have led, influenced either the conduct, I forget the exact terms I'm speaking of the top, but either the conduct or the election itself? And we would say whenever you are promoting actively your political ideology on a platform, you are seeking to influence the outcome of the election. It's not seeking to influence in a nefarious way. You're seeking to influence in the way that you would be doing ordinarily at an election rally. It's entirely legitimate. But when one does it in the context of a presidential platform, that is where, as Madam Justice Yakub has referred to it, the abuse comes in. That is the difference between the use of that platform and the abuse of that platform. Because one is using the platform of the presidential office to promote one's political ideology, to promote one's political campaign. And one's not doing it as the President often did, as was submitted to your Lordships and Ladyship in respect of previous fireside chats where the President spoke generally. It's critical to an appreciation of the context to understand the glaring reality, and that was that this was not only in the context of an election period, it was on the very eve of the election. So whenever one is promoting one's political accomplishments, one's political achievements, and recommending that one stay the course, it is, in our strong submission, impossible for it not to be interpreted by a reasonable observer that that is political campaigning or seeking to influence the outcome of the election. Again, I emphasize the seeking to influence is not a nefarious seeking to influence. You're seeking to have members of the electorate vote for you. In that respect, you are seeking to influence the outcome of
Does
the
it not have to be nefarious if it's abuse? I mean, doesn't abuse require...
Something more.
Absolutely, but firstly, let's start with use. You're using that platform, whether it's a party political platform or the presidential platform, to influence. The abuse, the test of the abuse with respect, comes in because you are using the presidential, a position of power in terms of the act, to influence. That is where the abuse aspect comes in. Otherwise, it would not be abuse. So that creates the abuse. So every time we would say a political actor stands up at a rally and seeks to espouse their political views, they are seeking to influence the outcome of the election. What creates the abuse under the code is that this is a person in a position of power using that position to influence the outcome. That is what creates the element of the breach of the code. If it was stated in another context, it would not constitute a breach. Finally, in respect of penalty and costs, the debate about the reduction in the electoral vote is hypothetical. As I've said, that was obviously sought at the time when the application was launched before the election. Much water has flowed under the bridge. My client doesn't proceed with that. The critical aspect, and this is where the charge of being frivolous is particularly harmful, the critical aspect is the seeking of the declarator. What the DA comes to court seeking is an indication from the court of whether the President crossed the line in his action, acted offsides. That is a perfectly legitimate and laudable political objective to seek before this court, and it's that the DA seeks to vindicate. That is not by no means frivolous, and as one can see by the nature of the argument that's taken place, it is by no means, at the very least, clear what the proper position in law with respect to that is. So the declarator is important, and we would say that a clear case has been made out that in those many respects, and it's not just a single respect, but that would be sufficient. In a number of very glaring respects, there's been a crossing of the line of the code and of the Act, both under the relevant section of the Act and under Section 9(2)(e) of the code, and that it's appropriate then that the court grant a declarator in that respect. The fine is within the court's discretion. And then finally, in respect of costs, we again indicate that if there is success, we do ask for costs on a party-to-party scale. It is a clear instance of a case of buy watch. You have two parties. We assume and we must presume that approach the court in good faith for the vindication of a constitutional principle. That is essential to our democracy. That is where the line falls in respect of acts by the President of the Republic. That is a issue of seminal importance for the purpose of our constitutional democracy, and it's one that falls clearly within the prescripts of the Biowatch case. So I leave you only with the following, members of the court, and I thank you for your time, but I repeat that having regard to the statements made, it must be remembered that this was the President making clearly political statements about achievements on the eve of an election when all other campaigning by law was forced to stop. And the question is, what would the reasonable observer interpret those statements as? Were they simply a matter of nation building, or were those statements of a political nature by a political actor, not in the guise of the President? And we say that the answer to that question is a clear one.
Just with regard to what we use as a guideline when giving content to the political campaigning or political statements, the Electronic Communications Act
And transit.
has got definitions of party election, broadcast, and political advertisement. And for political advertisement, it says it means an advertisement broadcast on a broadcasting service which is intended or calculated to advance the interests of any particular political party. And that's the part which I think would guide us in giving content. But the rest of it is where they haven't, whether they've been paid or not, because party election broadcast is where they haven't paid for it, and political advertisement is where they have paid for it.
Correct, yes.
But is that what we're trying to, what the problem is that the President's speech was a broadcast which is intended or calculated to advance the interests of that particular political party. And nobody else at that point in time was permitted to do that kind of broadcast. Firstly, because it was 48 hours. And secondly, that he didn't have to pay for it.
Justice Jacob, I think that is helpful as a guide, but I would just caution against using strictly the definition in the Electronic Communications Act and the Broadcasting Act, because those govern very specific definitions for the purposes of those adverts, where there has to be a disclaimer.
Well, they govern the access that the broadcasters have to do, and what they have to do. But in terms of context, content, and access,
yes,
those would be relevant.
yes, I don't want to be reluctant to embrace it, but I would say that that is part of the core of the meaning, but I wouldn't say it exhausts it.
You wouldn't tie yourself to it
exclusively, because the acts use different terminology. They use broader terminology than that, whereas those acts that you're referring to, Madam Justice Yacoub, are have a particular technical meaning because they pertain to broadcast rights and obligations.
But your complaint is that he got access to a broadcast in circumstances where he would not otherwise have been able to get access if he had not been the President.
That's an
because of specifically this act.
Very important aspect of it, but not the whole of it, because it was also broadcast as the President on other presidential platforms where you don't have to seek access as under the Broadcasting
So if he
Act.
hadn't been on the SABC, if it had just been on, what is it, X and
YouTube and
Instagram
yes,
and whatever the latest TikTok thing is,
would also have
you'd
have
also
engaged
have
the
a
breach of the
complaint.
code. On both it would have engaged the breach of the code. It's not only, that is part of it, but not only it. And that's why it is not simply a complaint under the Broadcasting Act, which would be brought against the state broadcaster. It's a wider complaint.
But then that part of it would be relevant to
Would
giving
be
him
relevant,
content,
necessary but not
the
sufficient.
only- okay.
is the way I'd put it. Yes,
These are submissions, Mr. Steen. Any questions? No further questions. Okay.
as the court
Come to
pleases.
an end of our deliberation and submission. Thank you very much for the manner in which you have dealt with the matter. And your submission will assist us in the preparation of the judgment. So the court will preserve the judgment.
My Lord, I'm so sorry to interrupt, and I've neglected to hand up a note on jurisdiction which covers exactly what we said in argument. It was only completed while I was in, it was only printed. Can I be permitted to hand that up and to pass
Let me
it up?
find out from your colleagues. Have you
They-
had
they
sight
also-
of it?
We haven't had sight, but it's more my learned friend who.
May it please you, the court. My Lord, without having had sight of it, I'd be reluctant to allow it up. Perhaps if my learned friend gives it to us, we can look at it overnight, and if we want to address it or deal with it. But it should have been given to us before my learned friend's address.
It covers our argument. It doesn't, but
We would object.
It's fine, and you can just email it to us if there's no objection.
Well,
we
there's an
don't, we're
objection.
reluctant to
No,
open.
no, I mean tomorrow if there's no
Yeah.
objection.
Well, if our learned friends would let us have a copy, we can have a look at it.
Yeah.
Thank you.
Thanks.
Well, I think that the sensible way to deal with it, send it to the other side. And depending on what they say, then they'll be entitled to file a short note arising from the note that you've exchanged, just to make sure that everyone has got an equal opportunity.
Yes, it's
But
really.
if they look at it and they say, well, it doesn't, it's not controversial, then I think that I guess it can come in.
It's only in response to a note that we were handed, and that's why it's late and could only be printed out. We were handed a note in the course of just shortly before the address, and so I couldn't prepare the notes before that. So that is why. But I'm reluctant to open a can of legal worms. We'll hand it to them and we'll see what their response is. I'm reluctant to invite further submission.
Okay,
As the court pleases, my Lord, we'll sort it out between ourselves.
sure.
Thank you.
Mr. Steen, these are your submissions.
Those are our submissions. Thank you. I'm better to you.
All right, as I've already expressed our gratitude to counsel, and I've indicated that the judgment will be reserved, so you'll hear from us. Thank you. The court adjourns.
Is it one of them?